I appear for the appellants in serial number 9, my lords.
For the response.
Yes, my lords.
When for the-
May kindly be have it on Wednesday, my lords. There's some inconvenience today, my lords. No, my lords, the arguing counsel is unwell today. Any other day, my lords.
My lord, serial number 27. I appear for the appellants, praying for 1 week time. Senior is not here, not on.
My lordship may leave, but I appear for the respondent. Senior counsel has been engaged. Leave will be taken next Friday, madam.
My lord, the date may be fixed.
Friday, coming to that.
My lord, the interim order.
My lord, seal number 35, I appear for the respondent. I seek time to file objections to the IA for condemnation as well as stay, my lord. There is a conditional stay that's already been granted by this honorable court. I request for some time to file my objections to the two applications. No, my lord. But there is an interim order that's operating in their favor and it's not court hall moved, so I'm taking the liberty of making a mentioning. I apologize, my lord. I will. Please, please. I answered. I apologize, my lord. I will.
My lord, serial,
I am the respondent, the appellant. Please. I will take his details. I'll inform him, my lord.
my lord, serial number 36, my lord, senior Husharilla Swami. Serial, senior Husharilla Swami, 1 week time date. Appellant, my lord. Appellant, my lord. Senior Husharilla. Marty Swami, 1 week time big Swami, senior.
Serial number 65, my lord. Serial number 65, my lord. 5. I appear for the appellant, my lord. Kindly grant us a short accommodation. My lord, as we have taken steps with the paper of publication also. None has filed the wakalat or none has come before this court, my lord. My lord, I'll inform my lord. My lord, meanwhile, the interim order may be extended. Interim order may be extended. My lord, serial
Obligation.
number 58, my lord. We informed the other side counsel, madam, my lord. Appear for appellant, my lord. We engaged senior counsel. Please, madam. We engaged senior counsel Jay Kumar S. Patil in Northern States, my lord. Kindly have it on 10th, my lord.
Particular date, 10th.
Serial number 1, I appear for the respondent in the first matter. In other matter, I am appealing for that. I need certain instructions from the.
My lords, if
they have been discharged from the schedule of offence, I will make a statement.
my lords, if
And
I may,
according to the
I may be
proceedings-
kindly be permitted to produce the discharge order in the schedule offense, as well as the PMLA proceedings as well, my lords.
I collect the papers from him and I will take instruction, my lord, I will.
My lords, my respectful submission would be this, my lords. With respect to item number 1, my grievance is with respect to 2 findings in a particular paragraph. The tribunal comes to a finding that these are not proceeds of crime. However, it applies equity and says for the purpose of equity for balance of convenience, I am asked to deposit 5 lakhs as demand draft. It is not. I can point it out, my lords. There is a categorical finding that it is not proceeds of crime. Both the schedule offense stands squashed as well as the section 45 proceedings under PMLA. I am discharged in both.
That is the case, my lord. In the teeth of Vijay Madanlal Chaudhary, if they have been discharged, in the teeth of Vijay Madanlal Chaudhary, I will make a statement.
I'll make
1 week.
9th, we have a matter there.
Yes.
My lords, any date apart from 9th, I'm sorry, I have a.
17.
Acha.
Appellant in this case, my lord. I request 1 week's time should be granted in this case, my lords. Serial number 3, my lords.
Yes, for and connect the matters. You have to. You will see that concept from Delhi. Yes, connect.
Yes.
Five. Hanmant Reddy ji.
Waiting for the appellants of the National Highways Authority.
What is the enhancement award?
Take the page number 49.
Arbitration award of 2025.
23.
What is the enhancement also?
75,000%. It was 9,600%. Subsequently, the enhancement has been raised to 75,000%.
In these of matters,
Please,
what happens to the others? They've been admitted,
please.
other appeals,
Other appeals, some of the appeals have been admitted. Please, it has been
the
admitted.
same survey number.
I'm not unaware of the, in respect of the same survey number. But appeal challenging the arbitral award. Please, please.
Index is widely.
Please,
3A1 is on 8/9/2021.
please.
In respect of this notifications, there are other appeals pending. Same notification.
Lord, on that note, in that regard, I can, if I'm unaware of the, in respect of the same notification.
Weeks.
There are,
3% 6 weeks.
50%.
Six adjourned, 7. Manu Prabhakar Kulkarni.
Please.
8. Samra Sikri.
Appear for the applicant, my lords. May I request a passover? We're being led by senior counsel, my lords.
Passover, my lord, kindly accommodate another day. I'm held up, my lord. So if your lordships can accommodate. No, my lord, if your lordship, if it is request for Passover, then I request for urgent. Because I have some, I'm committed, my lord, in number of matters today.
Sir, could we have it tomorrow?
23rd.
My lords, may we have it tomorrow in that case?
I know, it's tomorrow, it's subject. I vote. I vote.
30th. 30th September.
My lords, there's an interim order operating against us in the trial court, my lords. That's the difficulty. We're only seeking interim relief today, my lords. My lords, if my lords may then have it today, my lords.
23rd. 23rd.
23rd September.
My lords, in the two connected matters, there is an interim order, my lords. That interim order may be extended. Pleasure.
9 adjourned, 10. Pradeep Nayak.
Here for the appellant in 10 and 11. This is a trademark matter. Both two applications were filed. Very briefly, the plaintiff is a company that has incorporated in 1998 in Hyderabad, called Rainbow Children's Medicare Limited. In 1999, it opened a pediatric specialty hospital under the name of Rainbow Children's Hospital. 2005, it got its first trademark registration in medical services under the name Rainbow. Since then, it has got multiple trademark applications in registrations, including for the word trademark in multiple languages. The respondent is a hospital in Bangalore, which claims to have started in the year 2013. Please.
So may I just make one submission? But the parties are in mediation for the Bangalore Mediation Center.
My instructions are, so we had an ex parte interim order until this order was passed. The Honorable Court finds I am the prior user, finds that there is a likelihood of deception and confusion. But it says they started in 2013 in Bangalore and we came in 15. Therefore, the prima facie balance of convenience is in their favor. And that I have not taken attempts to find them and file a suit before today. So ex facie, it is in the face of Supreme Court judgments. Deep.
It may be had, after the mediation, because 13, we are before the mediation center.
As a mediation, we are proceeding in good faith.
It will upset the equilibrium. Please.
The impugned order. The findings, my lords, in the impugned order, only 6 paragraphs from 36 onwards. Until then is all submissions. If you're best.
11. Same. 12. K. Ravishankar.
Yes. Look, no. Notice issued by the arbitrator that came to be returned as at Now the execution is filed. I was given an understanding by the guarantor himself that I was not put in even in the execution also. Now they are taking a coercive steps, my lord. I have paid 5 lakhs and 2 lakhs, my lord, they have recovered. As on the date when the arbitration was invoked, the outstanding was 7 lakh as on the date when the arbitration is invoked. Now it is 19 lakhs as on the date when the execution is filed. According to me, 5 lakhs have been paid, my lord, as the loan account, and 2 lakhs they have recovered by putting the vehicle on auction. As far as me is concerned, my lord, the entire due as on the date arbitration is invoked, my lord, entire I have cleared. The learned arbitrator, my lord, without ensuring the service of notice, my lord, he passes an ex parte award, which was challenged. Please. I will also simultaneously take out the suit the council so that service will be complete. In addition.
30, Rashmi Subramania.
I am the plaintiff before the court. The suit is for a declaration that a lease deed entered into by respondents 1 to 3 before this honorable court in favor of 4 and 5 in a breach of my agreement to lease is not binding on me and for a specific performance of the agreement. Your Lordship may kindly turn to page 89. This is the agreement to lease between me and the respondents 1 to 3, who are the owners of this commercial property. Kindly turn to page 90, my lord. Yes, yes. But the description of the property, your Lordship may kindly see property particulars of the proposed mall said premises in future. Total area of the land, commercial premises at measuring approximately 15,400 square feet. Then, my lord, your Lordship may kindly turn to the next page. Clause A, page 92. Minimum guaranteed rent is prescribed. And then, my lord, the next line, the revenue share, 9% of the annual net sale, whichever is higher. But what I am submitting, yes. But my submission is this, my lord. The underlying use of this property is commercial. Nobody is disputing it. Even respondents 1 to 3 who are the owners are not disputing it. Their case is that when this MOU was signed, the property was not being used for commercial purpose. And therefore, it is not a commercial dispute within the meaning of that definition. That is the only, they rely upon a judgment of the Honorable Supreme Court. The facts are totally different. My lord, the application IA number 4 under Order 7 Rule 10, on the basis of which the learned, the commercial court has directed the return of the plaint is, yes, Trade and Commerce. Page number 214, minute. Paragraph. Yes, my lord, your lordships are absolutely right. That is the judgment. Para 12. Page 53. In the middle, but in my opinion, since the date when MOU was entered into between the parties, scheduled property was not ready to use as a commercial property, and no commercial transactions except the MOU took place between the parties. the argument advanced by learned counsel for defendants 1 to 3 has to be accepted. That is the only question that is involved. My lord, that is my lord, the judgment of the Honorable Supreme Court in Ambalal was, my lord, dealing with a different situation altogether. There the property was not even commercial property, it was being converted into commercial use. And my lord, in the plaint, I have very clearly stated it is commercial property and there is no denial. The only point, of course, my lord, when one tenant vacates and another tenant occupies, there is a vacuum. That agreement relates to that vacuum period and some repairs had to be done. Before those repairs were completed, my lord, the lease in breach of my agreement, the response 1 to 3 executed a lease deed in favor of 4 and 5. That is the subject matter. The underlying use. Yes, that is not denied. That is not denied at all. The underlying use of the property is commercial.
Well, signed for the R5, but application is filed by R1 to 3, my lords. Matter may be posted on any date for hearing, my lords, on final hearing.
My lord, the applicants before the commercial court are response 1 to 3, the owners. They are the lessees. Subsequent lessees. They have not filed the application. My lord, the court has directed that I should take back the plaint and represent it before a court of appropriate jurisdiction. That may be stayed, my lord. Great.
Five, I'm K-wait, I filed the K-wait, my lords, for 5.
Yes.
14,
My lord,
by Kini.
my lord, I appear for the appellant in this matter. My lord, the challenge, my lord, in this appeal is to an order of eviction. My lord, the property was being used for commercial purposes. We are running a showroom there. My lord, what happened, my lords, we have never defaulted in payment of rent. What happened, my lord, is there's of course a lease deed entered into in 2017 for a period of 9 years. It runs until 2026.
Don't, so that you don't have to run around last minute.
I'm so sorry. Well, what happened, my lord, is after the pandemic lockdown, my lord, the parties had agreed, and this is documented in emails, that we were given a rent waiver of 3 months. And they said, my lord, because the situation has not normalized, we will give you some 30%, 15% waiver of the rentals. This is all documented in emails between the parties. And we, my lords, an invoice is raised on us. We pay the rent as per the invoice. What happens then, my lords, in 2022, the landlord approaches us, says he wants to sell the property. We say that we have a lease till 2026. We've invested a substantial amount. My lords, we run a spectacles marketing company called Lenscut in the premises. And we say that we have a lease until 2026. We cannot vacate. Immediately after that, he files a suit for eviction on the basis that we have defaulted in payment of rent. My lords, nowhere in the plaint, and for that matter, nowhere in the impugned judgment, is it even identified which 2 consecutive months have we defaulted in payment of rent. Under the lease deed, my lords, we can only be evicted, the lease deed can only be terminated if there is default in payment of rent for 2 consecutive months. Nowhere in the plaint and nowhere in the judgment is that identified. What the learned trial court judge says in the impugned judgment is, exchange of emails is not sufficient. Since there is a lease deed, that lease deed can only be modified by a supplemental lease deed. And therefore, whatever may have been the exchange of emails, whatever may have been the waiver, etc., that I'm not going to look into. You have to pay as per that. But my lords, there was in fact no such notice at all that was given to us. And we have maintained a security deposit of around 10 months rent with the landlord. If in fact there was a default, he could have adjusted it from that. There is no notice given to that effect also. And now the trial court says within 60 days, we have to vacate the premises. We're running an operation there. It's a commercial business. There are employees working there. We're asking for a stay of the judgment. I'll serve the counsel who appeared in the trial court minutes, in addition to sending notice by RPA. I'm asking for a stay of this judgment. Look, the arrears, there are no arrears because Malas, they raise an invoice, I have paid it as per the, and in any case, Malas, the arrears can be adjusted against the security deposit. Malas, there are no arrears. That's my respectful contention. And in the judgment, Malas, this so-called, it is a fairly small sum, Malas, around 18 lakhs, 13 lakhs. There is no explanation or there is no breakdown of how this arrears has been arrived at. I have been consistently paying rent. Malas? Yeah, 11,83,000 millions. And even during the pendency of the suit, I've been paying rent. So the question of arrears doesn't arise at all. Millions, the rentals have been waived, but how this 11 lakhs figure has come, well, we don't know what is the basis. In the judgment also, there is no basis for this 11 lakhs figure. The breakdown, Malaj, of the 11 lakhs figure is not provided at all. But what is the breakdown? It says towards arrears of rent, electricity, which month, which invoice, which exhibit before the court, nothing is discussed. I have no difficulty, Manoj. If they come back and if they are able to identify what it is the basis, Manoj, I'll deposit that amount. There's no difficulty at all. But Manoj, there is no liability because I have been paying my rent scrupulously. Every time they raise an invoice, in terms of the invoice, I've been remitting the rent.
Rent and other charges have been paid. And invoices they were raised by the payments.
Deep refreshments.
15, Sundaraman.
I appear for the appellant. Rejection of a or refusal return of a plea for presentation before a court having jurisdiction by the commercial court. The purchase order, my lord, specifies Bangalore is the court which has jurisdiction. We raise the purchase order on them. Now the court does not advert to it at all. Simply, my lord, the court says that the court does not have jurisdiction on a basis that the production of the cotton yarn happened outside. I place a purchase order from Bangalore. I pay from Bangalore. The negotiations have happened in Bangalore. And not interestingly, an issue was framed, and that was treated as preliminary issue. But the what is allowed is the application under Order 7, Rule 10, which is IA number 2. As a matter of fact, the court had passed an order saying IA number 2 has become a preliminary issue. We laid evidence on the preliminary issue. None of it is considered. Not a single word is considered. Not even the purchase order is looked at. Lordship may kindly see the entire consideration starts at page 24, para 10. First statement itself in my respectful submission is wrong because it is an admitted fact that there was no written agreement or contract between plaintiff and defendant. A purchase order is a contract between the parties. And the purchase order specifically says that courts at Bangalore have jurisdiction. And that is not completely ignored. There's no reference to that clause at all, anywhere in the order. From Maharashtra. Order. The clause 32, my lord, of the 23 of the purchase order says exclusive jurisdiction is Bangalore courts. May I just pass it on, my lord? I have the copy of the purchase order. Give a copy. Give me the page. Can I request my lord to kindly come to page 72 at the bottom. The page number is at the bottom, my lord. Type page number 72. Applicable law. Purchase order shall be governed. I'm sorry. Clause 23. My lord, sir. And the courts at Bangalore, with the exclusion of all other courts, and each of the parties here to submit itself to exclusive jurisdiction of the said courts. UN convention shall not apply. This is our specific defense to the application. Completely ignored, not even a word about it.
Was argued, my lord, on this particular clause also. If there was any event conferring the jurisdiction on Bangalore has taken place in Bangalore jurisdiction, my lord, then this particular clause will kick in. If no event has taken place within the jurisdiction of Bangalore, in that event, my lord, by consent of the party or one party by virtue of this particular clause cannot confirm the jurisdiction. That was the argument that was considered by the court, my lord. And thereafter, my lord, this is what we have argued, my lord.
Argued.
Yes.
This clause is not even looked at.
My lord, I will the document what was placed before the court, everything we will place it on record, my lord, how it was considered, and definitely we will argue on that particular aspect. Any date, my lord, next week, any date.
In the meanwhile, nothing happens.
No, now the plaint is returned. Of course, no, now plaint is returned in the sense the order is passed to take return of the plaint. We've not yet taken it, my lord. But let the proceedings continue, my lord. We will record evidence. It's only at the stage of evidence. And now Supreme Court, my lord, may I just pass on one order?
Evidence was adduced, my lord. I raised this particular objection.
Agree.
For return. Now, I have not sought for the rejection of the plaint. I sought for return of the plaint. When I sought for the return of the plaint, the court framed an issue. Then they adduced the evidence. I cross-examined the witness. Documents were marked. Thereafter, this particular order has been passed.
Correct.
So we have to place all those documents on record. Then we will address that.
Lord.
Yes,
That's
the
not
evidence has
considered.
been adduced to the difference.
No, but there's no.
I will explain, my lord. Yes.
In a similar circumstance, my lord, there's one order, interim order, where it was returned. Supreme Court said, let the proceedings go on, but no final judgment be passed. Lordship may kindly see on the second page. Last paragraph. In the meanwhile, operation impugn order shall remain stayed. Proceedings before the so-and-so may continue. No final order will be passed. We'll need evidence, my lord, and that's all.
Is it not better that we send this
Right.
question first and then you can?
Very well, my lord. What?
Yes, yes.
Can I request a date, my lord, so that 18th? Can it be 18th? 18th. I'm grateful.
Great.
I'm- I'm grateful.
16, Manmohan PN.
Lord, I am a developer. There's a registered development agreement in my favor. No, may I just pass on the agreement copy. On the 25/11/2022, Lord, is joint development agreement. After which, Lord, I obtained conversion of the land. Lord, thereafter, Lord, on 26/6/2024, respondents 1 and 2, Lord, execute gift deed in favor of, Lord, respondents 3 and 4. My JD is still, Lord, in existence. And Lord, I seek for an order of injunction, Lord, under section 9. But the order of the trial court is at page 18. One into the landowners with whom, Lord, I have the joint development agreement. And Lord, they executed gift deed, registered gift deed in favor of, Lord, respondents 3 and 4. Our respondent number 1 executed in favor of respondent number 3. Respondent number 2 executed for respondent number 4. But they are also, Lord, family related to them. Related to them, Lord, sisters. Yes, Lord. Basically, Lord, that is all. They only sought, Lord, not to alienate or encumber the land. The trial court, Lord, only, Lord, issues notice. Page, Lord, 18, Lord, is the order. There is nothing, Lord, in the order. Memo, Sahib. Please, Lord. Lord, what happened was, Lord, by inadvertence, the commercial appeal was filed. Then we sought permission to convert it. Lord, so seeing the JDA, Lord, should I take my Lord to the JDA? Very well. No citation. Now, Lord, they're seeking for change of khata, Lord, by virtue of this registered document. Lord, page 18, Lord, starts at page 17. Yes, Lord. Page 18, Lord, is the order. A petition is filed under section 9 of the Arbitration Act. Is under and IA number 1 for interim temporary injunction to restrain respondent from alienating the scheduled property is filed. According to the petitioner, petition number 1 to 3 and respondent 1 and 2 being owners of the petitionable land entered into joint development agreement dated so and so, along with wife of respondent number 1 and sister of respondent number 1 and 2 with the petitioner. Said agreement contains arbitration clause, and now respondents are going to alienate the scheduled property to third party. After careful consideration of the case made out by the petitioners, I am of the opinion that it is necessary to issue notice to the respondent before passing ex parte order. But in fact,
What happened on page 9?
Lord, it is now adjourned, Lord, to 30th of September. Insofar as fourth respondent is concerned, displays ex parte, Lord. Sought not to alienate or encumber the property. Page 33, Lord should get it. Great. Lord, the trial court, Lord, they still yet to appear. Lord, sir, permitted me to serve, but they still not appeared as yet. Not yet. Very well.
Grateful.
Preliminary hearing, seal number 17. G.S. Prasanna Kumar.
Appear for the appellant. Your Lordship, the declaration is pursuant to the MOU, that is the family arrangement. Based on that, we sought for the declaration. Declaration has been registered under section 17. Your Lordship, the MOU is that the originally family belongs, property, this declaration, what we sought belongs to the one family of the Loenka.
Would it not be the family agreement or MOU, whatever you are, by which the right passes? That has to be
Yes, see, right already,
declaration by you.
yes. My submission is that through the MOU, already rights was accrued to the appellant. MOU is a family settlement.
Something which
No,
states
see, easy, easy.
experiment.
Yes, MOU is in the is in the form of the partition of the family. The family properties, either the companies and other family properties. MOU is executed in the year 2003 and MOU is coming to, is given effect by MOU. Through the MOU, shares were transferred to my name of the company. As per the MOU, all the shares were transferred in the name of the appellants. Based on that MOU, which rights already accrued, so we are sought for the declaration of that which rights is already accrued. The said MOU is a subject matter of the suit which already filed by the first respondent. The deed of declaration is the declaring that the MOU rights what we are accrued under that. Yes. Kindly say that, Your Lordship. First, I'll take out to the MOU because in the MOU, we are all the parties. MOU, my rights is already accrued. Yes. See, section 17, Your Lordship. So 17B is other non-testamentary instrument which purport or operate to create, declare, assign, limit or extinguish, whether in present or future, any right, title or interest, whether vested or contingent of the value of the 100 rupees. And so my contention is that since I sought for the declaration, my rights is already declared in the MOU. Yes. Documents of which registration is optional. Any of the following documents may be registered under this act in the instrument other than an instrument of the gift and will, which purport or operate or create, declare, assign, limit or extinguish, whether in the present or in future, any right, title, and interest, whether vested or contingent of the value less than 100. The instrument. My contention is that if any documents which is through the declaration, I'm going to declare this is the property I'm acquiring. My contention is that since my right is already accrued.
Register the declaration. What is the position with respect of compulsory registry documents? By which title passes?
Yeah. My contention is that, Your Lordship, see, if through that the non-testamentary documents which through Your Lordship, I am through the declare, I am declaring certain rights and titles under section 18. But here, the MOU is already given a right to me. But the MOU registration is not a mandatory because it is a partition. So based on the partition, Your Lordship, I got the certain.
It ought to be registered in book 4, Mana, but under section 167. The rule 167, Karnataka registration rules, Mana, 1965. Yes. Procedure when a document is registered in a wrong book, Mana, that ought to be adopted. Yes. Rule 167. Page number 345. 345. 345 of the same book, Mana. Rule 167. Yes. If the document has been copied in the wrong register book, the sub-registrar must obtain the previous sanction of the district registrar to make a fresh copy in the appropriate book. The copy in the wrong register should be completed even if the mistake is detected before copying the document is completed. The copy in an appropriate book will be made from the entry in the wrong register for which the document should not be detained pending receipt of the district registrar sanction, but should be returned to the party concerned. The serial number given to the entry in the wrong book will not be cancelled. In the book in which the deed was first erroneously entered, a red ink footnote should be added to entry, showing where under the orders of the district registrar it has been recopied, and in the book in which recopying has taken place, a red ink footnote also should be added to the entry, showing where the first copy of the deed appears in the wrong book. These footnotes should be signed by the registering officer. The serial number appearing on the copy of the wrong book should be recopied in the appropriate book, but a fresh serial number in sequence of the entry in proper book will be given to the fresh copy. The copy of the deed in the wrong register will in no way be cancelled by the registering officer. Property in such cases wrongly classified in annual returns before the mistake is discovered need not be transferred to proper class in returns of the following year. Similarly, index entries in the wrong indexes shall not be cancelled, but entries in the proper indexes shall be made in the sequence of the entry made in the proper book and cross references given in both in the indexes against the entries. Yes, ma'am. Real challenges saying that the registration one is wrong. Scope is considered which you did not do anything to the 167. You would have, as a matter of fact, you were alerted. You could have done. You did not. It was not done. It is brought to the challenges raised. There also testify. You don't say that it is a wrong entry, therefore we correct it. You testify. What by itself is wrong entry and sections are said. What can the appellate court say with respect to? This is the procedure which could have been adopted. Even now, the challenge was raised. It could have been. Yes. Probably is a wrong entry. Can be. Yes, correct. It shows up everywhere as if it is a change in text. And you'll be entitled to seek for change of kata with this. Cannot be resolved. It's a declaration. He says there is a family agreement. Registered.
That is the contention, right? Apart from that, by using this entry, which is made at a book one and using that entries in the encumbrance certificate, he is proceeded to execute a lease deed in respect of the property in which he is not even in possession, in which I am in possession now. And when the original documents of title is with me in the name of the company in my custody. And my lord, interestingly, just the reading of the deed of declaration, just point out page number 183. Very interesting declaration he makes in the deed of declaration. 183. Of the petition. Clause 7, clause 6 and clause 7. That I think the absolute one. Sorry. 183. Oh,
Yes.
Clause
Paragraph 6 and 7.
Paragraph 6 and 7. Says that I being the absolute owner of the scheduled property in my individual name. That when he says on the one hand that I have gotten the shares transferred, etc., in accordance with the MOU, there's no document produced showing the transfer of shares. No, he said it's a self-declaration in my individual name with the attendant right over of ownership, possession, and enjoyment. Attendant right.
And he is the sole executor.
Sole executor. And then, my lord, clause 7 says this deed of this declaration is being placed on record, subject to documentations to be made as required by law at a later date. I mean,
Yes.
Your Lordship.
yes.
Your Lordship. Yeah.
Scheduled property is allotted to the declarant. I have been put into possession and in that scheduled property had been earlier allotted to person in possession certificate in favor of sole. That so also has sold the property to a deed of sale agent. 25/6/1990 registered in book one. And document numbers also.
That is the sale through which I bought. The company bought. Respond number one company. Under two separate sales. Correct. In 1990. Schedule A property and Schedule B property and two separate sales in 1990. Now, where is the question of this transfer of share? In fact, that MOU, my lord, peruses the MOU. All that it speaks is as certain obligations which are there between parties to be complied with, based which, if that conditions are complied, then a separate deed would be executed, which was never done. And rightly, as my lord pointed out, at least if that MOU were to be registered and those clause conditions, then it would have been a subject matter of different thing whether I have complied with the clause, not complied with it. An unregistered MOU, never acted upon.
Or the actual deed which came about in terms of MOU.
Yes,
That
that could have been.
Your Lordship, my two
In
submissions.
fact, there's a, sorry, one last. I have filed one injunction suit. I have got an ex parte order of injunction, which is still in force. My party to whom I entered into an agreement to sell with, we found out saying that these are the anomalies here and these are the deed of declarations which are coming into place. He has filed a specific performance suit against me. And now, my lord, he says, and when the High Court, my lord, when the learned single judge has rightly identified the anomaly here and said that this cannot be done in law, and when the government also seeks to justify it by saying that it was just a mistaken entry, which was never rectified till date. Now, my lord, I have nothing more to submit apart from this.
Your Lordship, my two submissions. Your Lordship, first submission is that, see, the petitioner who is the first respondent here, is not having any locus standi to question. Neither is authorized by any of the members of the company. Nowhere is related to the company. That is the sole grounds we are taken in suit also, because suit is represented by GPA holder. Neither they are represented. Your authorized signatory is not having any right to represent the company, because company is at present in our custody, in the custody of the petitioner herein, because under the MOU, the same was intested to us. First. Second thing is that, Your Lordship, since I got through the MOU is subject matter of the suit. After filing of the suit, almost 7 years of the filing of the suit, they come up with the the challenging the said declarations which were declared in the year 2008. First, your lordship, since only to get the relief in the suit, they come up with that. There is a almost 2015, 7 years, 8 years delay in challenging this declaration. These declarations were registered in the year 2008. They are questioned the same in the year 2015. Because company all along is in our hold, he is not having any locus standi. To question the locus standi, this deeds he had to prove before his rights before the civil court. That he already prefer the suit. That is true in the year. Your Lordship, I presented the declaration based on the MOU. It is the government either mistakenly, if it is put it in book 1 also, they may rectify it as a book 2. But my right is not accrued under this declaration. My right is already accrued under the MOU which is already acted upon. Shares were transferred in my name and company. Yes. Yes, yes.
Because a matter of fact, the MOU has been acted upon. If the conditions have been complied with, probably you'll be entitled. That is completely another question.
Yes. My contention is that, your lordship, when suit is pending, suit is in fact. So after lapse of almost 7-8 years, they are questioned this declaration, which is already in force from 2008. Suit is at 109 page. Writ petition, your lordship.
Produce this counter which he is filing.
No, it repetition, no notes, no notice. No notice has been served. I'm not represent that before the.
Order clearly speaks of, but when you see the order. Can you see the order, my lord?
Yes.
Mr. Sridhar, it's like HCGP for R2 and R3, notice to R1, 3 and 4 are served under order dated 10/7/2019. The cost title speaks of it in the order itself.
But fact is that, your lordship, so we are not able to represent because that is not. See, after 2015, in the pendency of the writ petition also, in suit also, several dates were coming. But in suits, you nowhere is pointed out that we are prefer the writ petition. At least we come to know about the pendency of the writ petition. 2015 writ petition is also filed. 2015. The same is served. We are representing 2018 writ petition filed. In the pendency, in the suit is no point of time he raised that issue. We are prefer the writ petition. For that reasons, we are not aware about. But that it reflects, but I'm not come across with the.
But one more small difficulty, my lord. The sub registrar, my lord, when we go with this order of writ, my lord,
still not entertaining that. He is still keeping it pending. He says that that one direction is. Please.
ನನಗೇನು ಸ್ಪೆಸಿಫಿಕ್ ಇಲ್ಲ, ಕ್ವಾಶ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಎಂಟ್ರಿ ತೆಗಿಬೇಕು ಅಂತ ನಮಗೇನು ಡೈರೆಕ್ಷನ್ ಇಲ್ಲ. ಅದಕ್ಕೆ ಹೇಳಿ.
Lord, if there is a direction, my lord, we'll get it comfortable.
I,
Please.
here cancellation of the very declaration itself is that is available only. They may enter either this way or that way.
Saying that registration in book one was bad. You don't like it.
So
Reasons for.
only my submission is that your lordship, let them reserve the liberty to the appellants to that, request them to that, let him they enter the book, because entering the book one itself is bad. It does not mean that the very declaration.
Here is represents. This is an intra-court. Or we are.
Your lordship.
Everything else can be done. All your contentions will be decided in the Zoom and any other appropriate.
Because either if I am not entitled to entered in the book one, I'll at least I am entitled to entered in the as per section 18.
Here and anticipated.
No, your lordship, problem is this, your lordship, 2008 declaration. Yes. No, your lordship, my information is that contention is 2008 registration. Till 2018, he was not questioned the same. Said did, even though he filed 2015 suit, 2015. After filing of the suit also 3 years, he was not taken any steps to question the same. Because keeping in that mind, 10 years delay in challenging the said declaration.
18, BB party.
Lordships may see, my lord, this order is based on the earlier orders passed by this honorable court at internal page 5 of the judgment, my lord. Lordships will see the reference to Anita, Purnesh, etc. So this, my lord, was challenged. This is basically, my lord, the fate of this writ appeal depends on the fate of these Now, the Honorable Supreme Court was pleased to dismiss the SLP against that order of the division bench in SLP number 2888 of 2016 on 5/8/2016, my lord. I'll place that on record. 2888 of 2016 on 5/8/2016, saying that looking at the facts of the case, we do not find any merits of the petition. Special leave petition is accordingly dismissed. So once, my lord, the judgment based on which this judgment is, my lord, passed has been the honorable court's decision has been, my lord, upheld, affirmed by the Honorable Supreme Court by dismissing the SLP. Nothing remains. Therefore, my lord, I am sorry that I had told my learned friend that I'll file detailed objections. But, my lord, since I saw this just now, as I was making this presentation, I owe an apology, my lord, to my learned friend because yes, that preliminary notification in the earlier round itself, my lord, lordships will see the reasoning assigned in page 4, internal page 4, lordship pursuant thereto, petitioners file. Am I reading with your lordships, my lord? Page. Yes, I'm sorry. I'm so sorry. Please. I will give the SLP order also. Correct. Oh. Correct. KDB Act is a special act. So the Land Acquisition Act does not govern it. So on the same principle, if SLP is dismissed by the Honorable Supreme Court.
We'll look into it, my lord. Your lordship
I will
have it
provide a
next
copy.
week.
I'll provide a
No,
copy.
I have noted
apology.
the
I only have one clarification to make, my lords. The learned counsel for the respondent is relying on the judgment of a division bench of this honorable court, which has attained finality. Now, my lords, under the KID Act, there is no timelines prescribed in the statute, as unlike the Land Acquisition Act or the present new act of acquisition under the. I'll only clarify further, my lords. Just a short issue. The issue, my lords, is one such situation came before a learned single judge of this honorable court, who was pleased to refer it to a full bench. Now, the full bench, having dwelled upon this issue, was pleased to find I have the copy of the judgment of the full bench also. The full bench.
Yes.
Because the full bench was only pleased to say that when there are no timelines prescribed, it should be taken as reasonable time. And what is reasonable time would be construed on the facts and circumstances of each case.
Exactly. The notifications, which were, if it is on identical notification, that is, in this case, the notification is, regular notification is verified.
No, my lords, there.
Very safe. The findings have been.
Lords, in as much as it being sick, so it was called in question before this honorable court and that got remanded back.
But I'm
Now,
told
that-
my
that is
other
one
friend was a
important-
party to the.
My lord, I argued in that matter, my lord. Basically, what went to the honorable, the full bench was, there was a question referred that perhaps there are two judgments, there is some kind of a discrepancy, it can be looked into. Full bench, my lord, goes through all of those judgments. And it finally finds that there is actually no that kind of a contradiction between those two judgments. They actually are within the facts and circumstances of the case and have to be read as such. So this unreasonable time, that where a statute does not provide. Within unreasonable time, you cannot exercise those powers. That, my lord, now subsequently has been upheld.
May I place that on record, my lord? I'm
My
sorry.
lords, in this case, no, my lords, they called it in question on proceedings before this court. It got quashed, only the final notification, it got remanded back. After the remand, my lords, they say that it's been more than 2 years. Now, whether the mitigating factors would be the remand, the characteristics of the land, because these are patches of lands in between a huge extent of land. So all these factors. No, my lords. I'll point out, my lords, here it got remanded back and it was now, it got quashed and remanded back.
May I pass it on the judgment, my lord, that I was referring to by the Honorable Supreme Court? I have given a copy. I'm sorry, my lord, crude way of presenting. I just, my lord, found it and taken print, will produce it.
We'll file a compilation, my lords. Rather, I would say, my lords, today at serial number 23, another matter is listed. I have filed the entire set of compilation there. But there, no, my lords, but there the issue. Award is not made. No, award is not made. My lords, ultimately, please. No, my lords, award was made in 2016. And it was deposited in civil court. And that proceedings was challenged before this court. This court was pleased to quash it. And my lords, we have also in our written arguments filed another contention there. Ultimately, my lords, I'm not saying they should be clubbed. What I'm saying is, what is a common factor between these two cases is that when there are an absence of timelines in a statute, it should be construed as a reasonable time. No doubt, no debate on that. It is settled. The Honorable Supreme Court has said time and again. Now, what would be reasonable is on this facts and circumstances of each case. In that case, the mitigating factors are different, and in this, there are different. This is my submission.
All that I'm saying is
I'll
the
file my
whole
notes.
reason why the KIDB was unsuited before the Honorable Single Judge is because of these orders, my lord, which have attained finality. Now, once they challenge that order and allow that to attain finality and no such contentions are raised, to raise that contention in my case and to say, my lord, this is distinguishable is not correct. The distinguishing factor is there in those as well as mine. Yes.
Not on merit, my lords.
Whatever
what I
it
say,
is.
Not dwelling upon, please.
Yes. The
23.
The order merges with the.
My lords, they may not be clubbed together, I would only request, because there is some subtle variation in the facts, but the principle that we are enunciating are the same is my respectful submission.
And the Honorable Supreme Court said we find no merit
It is not, my lord, as if they have dismissed it for default or something. They said no merit. Lordships may see that. No merit. No merit and.
My lords, there is another judgment of the Supreme Court which my lords, another judgment of the Supreme Court which I have filed in that compilation. There the Honorable Supreme Court says the question of law is kept up.
Illy, now my lord, delay condoned. Matter taken on record, found no merit and dismissed. This is, and that order is not challenged or Lord has attained penalty. Selectively to now say that based on that order, your order is passed, so I will challenge this. Not.
Please.
Not even know the merger is the.
Yes.
Not even know the merger is the decision.
That,
As a matter of fact, this is all there is.
yes.
Even raise those contentions in review petitions.
Or curative petition if any, or
Please,
Lord, they
please.
could. So that my lord having attained finality.
Date for posting can be decided along with.
Please, please, please.
Or it may be club, my lord, I have, unless my learned friend has any.
I wouldn't say club, my lords, because it would unnecessarily interpolate and burden the court as such. Now, as and when they come, we'll argue them separately.
On the same
But
day.
the principles are on the same day. I don't have it. Probably on the same. Probably
Great.
on the same. Please, please,
23.
please.
Great.
Deeply obliged. Deeply obliged.
19. Ajay Kumar. 619 days delay.
This BDM.
Application of the year 1987.
1987 was called into question in the year 2014. And the order. Petitioner's property in concern. True. I bow down to that. I bow down to that. It's the very fact that the latches in question itself were not explained. 1987 is my preliminary notification. 1990 is when the final notification is issued. It's 2014 they filed. In between, there are other suits which were also in place in between. I've got those copies also. I'll place that also in before the Honorable Court. And the order, my lords, with the order, it's only noted, my lords, that para 2. Note, first, notice is yet to be issued.
Obvious objections are not all cleared. No?
All clear. My lords, the very file my lords would note, my lords, it was quite difficult for me to get the entire set of the documents, little old one. The impugn order, my lords, para number 2, my lords, page 17. It's a matter of fact that the scheme is not implemented in its entirety for various reasons, and the land in question admittedly cannot be integrated with BTM 6H, nor can be utilized as a compact block for the formation of the layout. Coupled with the undisputed facts, a certain extent of land adjacent to the land in question are developed privately, and to the passage of time, the scheme has lapsed. This is the only reason. Why the delay, why the latches on part of the petition, it's not even explained, not even considered by the learned single judge. Well, if I bow down to that, I bow down to that, I bow down to that. Well, I see the point. I see the point. I see the point which my lords. I'm conscious of that fact. In fact, I was also thinking of the same, my lords, when I was going through the file yesterday. Please.
For respondent number 4, I shall take notice.
Please. Great.
20. Pradeep Pesak.
Appellate. Yes, my lord, yes, my lord, the writ petition, please see the prayer in the writ petition, Lord. Lordship gets it at page 54. it is just necessary, equitable and expedient that the Honorable Court may be pleased to call for the entire records, annexure Q, and grant the petition the following reliefs. Issue a writ of mandamus or any other appropriate writ or order or direction declaring that the comprehensive service contract as per annexure Q dated nil issued on by the sixth respondent is illegal, void and violative of Article 14, 21, 23, 39, 42, 43 of the Constitution of India and the provisions of the Contract Labor Act and various memoranda of settlements. And then we issue any other order. Now, my lord, annexure Q, if your lordship sees, annexure Q is at page 157. It's only an internal. Oh, sorry. I'm sorry. You'll have paste it. And I'll just. Annexure Q, the correct page I just point. Page 219, Lord. This is only an internal communication regarding details to be gone into before entering into new contracts with new contractors. Yes, my lord. Comprehensive service contract. It's only the kind of modality to be changed. That is all there is to it. Therefore, my lord, no contract in fact had been signed. Now, my lord, the writ petitioner is a trade union representing the service conditions of contract labor. Now, my lord, the right of a trade union in regard to a contract that a principal employer intends to enter into with a contractor. Now, my lord, that is controlled by the provisions of the Contract Labor Act. We are only required to ensure that the contractor has a license. And, my lord, the trade under which labor is sought to be employed is not prohibited under section 10. And, my lord, we comply with the requirements of the Contract Labor Act in as far as compliance with the provisions of the ESI Act or the Provident Fund Act. And then, my lord, that we should not pay anything less than the minimum wages. That is it. But then, my lord, the Act does not give them the right to have a hearing at a time when, my lord, I want to enter into a contract with a contractor. What is their legal rights? In fact, recognizing. Yes. Now, my lord, I have stated that this will not affect the legal rights of existing contract labor. I have also said that. It does not. Then, my lord, they say they have entered into a settlement with the contractor, where, my lord, the principal employer is only a witness. Regulating is a witness to that settlement. Is only a witness, is not a signatory to that settlement.
But this is a tradition, man.
One, my lord.
They've always been witness in all the settlements.
No, my lord, the issue is when you are seeking a right to interfere into the process of negotiation. Yes, the process of negotiation. Now, my lord, what is your legal right to say that you will not enter into, you will give me a notice, you will hear me? Now, my lord, this is not provided under the Contract Labor Act at all. In fact, my lord, the single judge also recognizes that fact and then holds that it is premature because, my lord, ultimately, if I enter into a contract, if it adversely affects the rights of existing contract labor, they have a right under the Industrial Disputes Act or under the Contract Labor Act to proceed against the immediate employer, that is their contractor, to ensure that their service conditions are not adversely affected by this new contract. They cannot come and then say that you will not enter into a contract at all. So, may not kindly see the order passed by the learned single judge. It's at page 24, my lord. Page 26, paragraph number 2. Perusal of annexure Q.
dated 15/2/2019, it is only an internal correspondence between the officers in respect of conversion of existing contract to comprehensive service contract. Thereafter, official respondents proceeded to proceed with tender document as is evident from R1 and R2. It is to be noted that the internal communication dated 15/2/2019 has not attained finality in issuing notification or order so as to convert the existing contract to service contract. Consequently, the present petition is premature. Accordingly, writ petition stands disposed of, reserving liberty to the respondents to finalize annexure Q in a known manner. Thereafter, it shall be communicated to the petitioner. Yes, till final decision is taken, the respondents are hereby directed not to proceed pursuant to R1, R2. With the above observation, writ petition disposed of. Now, my lord, it is fine up to this place. Please see the yes. Yes. Yes, my lord. R1 and R2 is a complete set of tender documents. Yes, my lord, tender documents. Then, my lord, kindly see, para 4, this is what affects us. At this juncture, the learned senior counsel for the petitioner submitted on instruction that if Q is given effect, rights of petitioner and service conditions will be affected adversely. Therefore, official respondents are hereby directed to issue preliminary notification, which is unheard of. There is a question of preliminary notification pursuant to Q, while inviting application from likely to be affected persons. On receipt of objection, suggestions from the likely to be affected persons, the official respondents are hereby directed to take note of and consider their suggestion, objections, and proceed to take final decision and communicate the same to petitioner. Therefore, my lord, yes. Yes. Correct.
Correct in the sense that you are going ahead with an implementing an initial Q in your tender documents, which apparently means that you have acted upon an initial.
My lord, we were in the process of entering into a contract with a contractor. As per tender documents, we have floated tender, we are calling for tenders. Now, my lord, once they apply, yes. Yes. Yes.
Not be affected at that stage, not be corrected as much as the tender document.
No, my lord, we have clarified it, my lord, before the learned single judge in our statement of objections. Please see, my lord, that this would not adversely affect the existing contract labor. We have also clarified that. No, my lord. That is not true. Please see, my lord, the clarification that we have filed. Volume 2, page 456. Yeah. Yes. Now, my lord, 457.
Yes.
The difference, my lord, between the existing one and the new one. We have said there is no scope. In fact, in the footnote, please see, my lord, other contract conditions remains the same. Contractor has to pay the same minimum wages or VDA allowances, statutory, non-statutory, other allowances for both types of contracts. Therefore, my lord, we have also clarified. No, my lord, the type of, what is the difference? Kindly see, my lord, the conditions here. Service contract for deploying manpower for housekeeping, the first one. Sanitation, horticulture, and office messenger works, foundry and forge division, including so and so. The new one, it is also comprehensive service contract to carry out sanitation. There is no distinction. There is no difference. The second one, contractor has to supply the manpower to HAL and work will be assigned by so and so on a day-to-day basis. Contractor has to deploy manpower to execute the work as defined in the tender document. Minimum manpower to be deployed and monthly consumable requirement indicated in the scope of work. Therefore, there also there is no difference. Now, my lord, number 3, as per mandates, based on actual physical attendance, then monthly consumables as per actuals, then based on quoted lump sum charges per month. Even there also, my lord, there is no difference. I am only trying to, my lord, change the manner in which work is executed. That's all. It does not adversely affect the existing contract labor. Now, my lord, what is the right of a? Yes. Yes. It's also the same. Yes, therefore there is no change. I have said there is no change also. Now, therefore, my lord, now this sets a precedent. Now, my lord, when Act does not give them the right, now, in fact, my lord, your lordships are aware, the Supreme Court, my lord, in Steel Authority of India, has considered the rights of the contract labor. Now, my lord, the Supreme Court says merely because, my lord, the contract labor has been employed for a number of years. Now, my lord, for various reasons, my lord, the contract labor system is being continued. So long as, my lord, there is no prohibition under Section 10 under the Contract Labor Act, my lord, the employer has a right to employ contract labor and ensure that their all service conditions are protected in the sense, my lord, that they are not paid less than minimum wages. Then they have to be covered both under ESI and then Provident Fund Act. In fact, my lord, we also ensure that those who work for more than 5 years, they are also paid gratuity. That also is ensured by the principal employer. Therefore, their rights are protected. So the Supreme Court says, now, my lord, that so long as there is no prohibition, they can be continued irrespective of the number of years. And they will not have a right to even to seek regularization, and they cannot proceed against the employer. They cannot. Therefore, my lord, the right of principal employer, my lord, they have no right to say that you will not enter, you will ask me, you will give me an opportunity, I will decide what are the terms and conditions of a contract. What is that right that has been given to them? Which law has given to them that right? My lord, that trade union can only fight against the contractor and not against the principal employer. Yes. Yes. Now, my lord, now, my lord, I have already filed a memo saying that I have already entered into a comprehensive service contract again in respect of some other works, my lord. Memo I have filed, I have already entered into, my lord. I have also said that it does not adversely affect them. Suppose, my lord, yes. Yes. No, my lord, some right must, that right must flow from a statute. My lord, I am more concerned about, as far as this is concerned, no, my lord, I have already executed, I have brought it to the notice of this honorable court. Maybe, my lord, in this case, your lordship may not decide that because I have already entered into a contract. And in fact, my lord, there was an interim order. Pursuant to the interim order, I have proceeded to execute it and they have not come forward. If it was adversely affecting them, they should have raised a dispute by now against the immediate employer, saying that it is adversely affecting. They have not raised a dispute. Therefore, my lord, to set a precedent to say that in future, now, my lord, there are about 8 to 10,000 contract labor are there, my lord, in the entire, in all HAL divisions. Therefore, my lord, that is seriously affect our legal rights, and therefore their right to say that every time I enter into a new service contract with a contractor under the Contract Labor Act, they have a right to be heard before I enter. That, my lord, is I'm concerned about. Now, my lord, one judgment, my lord, I would like to place, your lordship. This was in a different context altogether, but then it would help us. My lord, the first judgment is Hindustan Steelworks Construction Corporation.
Yes.
Now, my lord, here the issue was Yeah. Page 1, the short question that arises on the right-hand side. The short question that arises for determination is whether appellant, who is the principal employer, is liable to pay to the contract workers any amount which constitutes the difference between the wages payable to the contract labor by the contractor and the wages paid by the appellant to its own employees doing similar work. Now, my lord, the issue was raised under Rule 25, claiming that they are doing work similar to that of regular workmen, and therefore they must be paid wages on parity with the permanent work. Now, my lord, the Supreme Court goes into the question as to what is it that applies to the principal employer. The discussion starts, my lord, page 3, para 8. Under this section, the section is section 21, 20 and 21 of the Contract Labor Act. 20, my lord, if your lordship sees, liability of the principal employer in certain cases. If any amenity required to be provided in section 16, 17, 18, or 19 for the benefit of the contract labor employed in establishment is not provided by the contractor within the time prescribed, therefore, such amenity shall be provided by the principal employer within such time as may be prescribed. Then 21, responsibility for payment of wages. A contractor shall be responsible for payment of wages to each worker employed by him as contract labor, and such wages shall be paid before the expiry of such period as may be prescribed. Every principal employer shall nominate a representative duly authorized by him to be present at the time of disbursement of wages by the contractor, and it shall be the duty of such representative to certify the amounts paid as wages in such manner as may be prescribed. It shall be the duty of the contractor to ensure the disbursement of wages in the presence of authorized representative of principal employer. Therefore, this is the only obligation cast under 20 and 21 on the principal employer with regard to the service conditions of the contract labor. Yes. Para 8, my lord, the Supreme Court has extracted section 21, and then, my lord, the discussion is at para 8, page 3. Yes, my lord. The term wages for the purpose of 21, section 21, means contractual wages which are payable under the terms of employment as between the contractor, who is the employer, and the contract laborers who are his employees. Wages would also include, inter alia, any remuneration which the contractor is required to pay under any award or settlement between the parties or under an order of the court by reason of section 21 of the Contract Labor Act 1970, the principal employer is required to nominate a representative to be present at the time of disbursement of wages by the contractor to the contract labor employed by him in order to certify that the contractor has paid the wages. And similarly, a duty is cast on the contractor to ensure that the disbursement of wages takes place in the presence of the authorized representative in the principal employer. The purpose of keeping the representative of the principal employer present is obviously to ensure that the contractor makes full payment of wages to each worker employed by the contractor as contract labor. These wages are the wages which the contractor has to pay to his workers in terms of the agreement of employment or any award, settlement, etc. If the contractor does not pay these wages to his workmen engaged by him as per contract laborers, then under subsection 4 of section 21, the principal employer becomes liable to make good the difference and recover this amount to which the principal employer has paid to the workman of the contract from the contractor. Under section 35 of the said act, appropriate government is entitled to make rules for carrying out the purpose of this act. Accordingly, the government of Andhra Pradesh, Rule 21 of these rules requires that every application by a contractor for the grant of license shall be made made in the manner prescribed in that rule. Rule 25 provides that every license granted under subsection 1 of section 12 shall be in form 6 and shall be subject to the conditions stipulated in Rule 25(5)(a). 25(5)(a), in cases where workmen employed by the contractor perform same or similar kind of work as the workmen directly employed by the principal employer of the establishment, the wage rates, holidays, hours of work, and other conditions of service of the workmen of the contractor shall be the same as applicable to the workmen directly employed by the principal employer or of the establishment of the same or similar kind of work, provided that in the case of any disagreement with regard to the type of work, the same shall be decided by the Commissioner of Labor, Andhra Pradesh, who decides. In fact, my lord, our rules also have similar provision. The fourth respondent has, in the present case, obtained a license in accordance with the Act. The fourth respondent has applied for a license in Rule 21, and the license has been granted to fourth respondent. Inter alia, that condition in 25(5)(a) to the effect that fourth respondent was required to pay to the workman employed by it the same wages as those paid by the appellant in its establishment to workmen performing the same. Apparently, fourth respondent contractor did not comply with this type of license. The short question that arises for determination is whether the appellant, who is the principal employer, is liable to pay the contract workers any amount which constitutes the difference between the wages payable to the contract labor by the contractor and the wages paid by the appellant to its own employees doing similar work. The division bench seems to have relied upon Section 21(4) of the said Act for this purpose. 21(1), however, provides that the contractor shall be responsible for the payment of wages to each worker employed by him. Section 21(4) provides that if the contractor fails to make this payment or any part thereof, the principal employer is liable to make this payment and may recover the same from the contractor as set out in the subsection. Looking to the definition of wages under the said Act, read with the definition of wages in the Payment of Wages Act, which we have set out earlier, it is clear that Section 21 deals with the payment of contractual wages by the contractor to each of his worker. The definition of wages would cover within its scope, inter alia, also those amounts which the contractor is liable to pay to his workers under any award, settlement, or order of the court, as well as other amounts falling within the definition of wages and under the Payment of Wages Act. Subsection 2 provides a representative of the principal employer supervising this payment. Clearly, therefore, the wages which are the subject matter of Section 21 are specified terms which are payable in presentee by the contractor under the terms of his contract of employment with each worker, as well as under any existing award, settlement, or order. Section 21 does not deal, nor does it cover obligations which are imposed upon a contractor under the provision of such rules. Hence, 21(4) will not apply. Such obligations of contractor which may be subject matter of the dispute between the contractor and his workers at the time of disbursement of wages and which do not fall within the definition of wages in Section 21. Rule 25 imposes on the contractor certain conditions subject to which a license is granted. One such condition is to the effect that the contractor shall not pay to the contract labor in his employment wages which are lower than the wages paid by the principal employer to his own workers, which do the same or similar kind of work. This is a condition of the contractor's license. There is no provision under these rules by which the principal employer is made liable to payment in the event of non-compliance by the contractor with this condition. If the contractor commits a breach of the conditions of his license, he alone will take the consequences. The right of the workers to recover any additional wages which may be so determined would be against the contractor. 21(4) has no application. Therefore, my lord, the Supreme Court says, no, my lord, under 21, what is the obligation? Obligation of the principal employer under 20 and 21 is only to ensure that, my lord, the admitted wages are paid. Now, my lord, a distinction is made that even when there is an order under Rule 25, that would not be an order which can be enforced against the principal employer. Therefore, my lord, when the Supreme Court goes to the extent of saying that your rights are only subscribed by what is provided in 2021. Now, my lord, the Act does not provide for a hearing before a principal employer enters into a contract. All that it requires is the contractor to whom a contract is given should have a license, and my lord, the principal employer must register. There is no dispute about that, my lord. Therefore, my lord, what is their right now to say that before you enter into contracts every time there is a change, you give a right of hearing, you decide, you issue a preliminary notification. And my lord, it's not a case as though, my lord, that the existing contract labor has been terminated because of the new contract. That is not their case. If, my lord, their grievance is that they have now produced a settlement, my lord, which your lordships have seen. That settlement, along with an application they have filed, my lord. Kindly see the settlement.
Yes.
Now, my lord, that settlement, your lordship sees, we are only witnesses there. It is between the union and the contractors.
This is on.
This is, yes, ma'am. (2010, 2020).
Yes, sir. So this is-
Service conditions of existing contract labor with, and these, yes, my lord. Your lordship sees page number 1 of the settlement. This is, my lord, your lordship will find Santosha BM, that is the contractor. There are 3 contractors here. And my lord, this is the, yes, my lord.
Payment of wages as specified here.
Yes,
Agreement that you must enforce under 21.
yes,
If the contractor does not
comply. We will ensure that it is paid and we'll recover it from the contractor. And my lord, if there is any, if my lord, there is a violation of the terms of this settlement, now my lord, they cannot come before my lords under 226. Now my lord, under the provisions of the Industrial Disputes Act. In fact, interpretation of a settlement, my lord, is also a matter to be referred for adjudication to the labor court under section 36. Yes.
were not the stranger, the scheme of the contract labor convention.
Yes.
Who are not a stranger to the process between the contractor and the contractor.
Yes.
Who are also expected to have a role.
Yes.
Therefore, to say that consulting them at the stage of change in the.
No, at the stage of entering into a new contract, what happens, my lord, is, now, my lord, this contract may be for. No.
They are no right.
No, my lord, they have no legal right to say that, my lord, every time my lord, your lordships have seen contract is there for 2 years or 3 years or 4 years. Once the period of contract is over, we may either renew that or we may float a new tender and we may have new contractors. Now, my lord, for them to say that whenever you do that process, we have a right of hearing, my lord, that is not sanctioned by law. That is the only issue which is involved in this. Otherwise, my lord, if they are by that action, my lord, if they are adversely affected, they always have a right under the provisions of the act.
Yes.
Respect, my lord. My lord, there are 3-4 propositions, my lord, which I'd like to place before this honorable court. Firstly, my lord, the nature of this contract labor, this is more in the nature of a permanent contract labor force. These are not workers who have come yesterday and gone, my lord, and who are replaced. This is not that way. And of course, my lord, this is the understanding between the workmen, the union and the management, my lord, that the contract workers' employment will not be affected, at least till now. Now, when we came before this honorable court, our apprehension, my lord, is that para 16 of our writ petition. We very clearly laid out what our apprehension is. My lord, may please see page 43 of volume 1. Para 16, please, my lord, 42. If my lord may please, from para 7 onwards, there are almost 4,500 contract workers, my lord. And this is the only union that represents the interests of the contract workers, my lord, at para 7. My lord, would please see para 8. We've also described the work that the contract workers are doing. Now, my lord, this is a public sector undertaking. And like all public sector undertakings in Bangalore, my lord, which I've had the opportunity to represent for many years now, contract labor is not in any just some incidental process. It is in core, it's on the floor, it's in production, it's everywhere. The management's what they say, even the public sector undertakings, because there is no order under section 10, nothing bars us. If there was an order under section 10 saying that this is perennial in nature, contract labor ought not to be employed, then I'm affected by the law. But because there is no prohibition, I can engage wherever I feel like, as long as I have the registration certificate, license is given under the Act. My lord, of course, just to say as an aside, after the judgment of the Honorable Supreme Court in SAIL in 2001, there is no incentive for any contract worker to push for abolition. Because Air India at least said, my lord, that you will be automatically absorbed. SAIL says that you don't have the right. So today, no contract worker is ever going to say that abolish under section 10 and we will get absorbed. That right does not accrue to them. So this is the nature of employment that is taking place, my lord, in public sector undertakings in Bangalore, including the management. At para 8, my lord, we've also shown the various departments where the workers are working, the contract workers are working. Para 9 may please be seen. There are 3 categories, my lord, of contract workers. There's a semi-skilled category, there's an unskilled category 1, there's an unskilled category 2. And these workers, my lord, which we have averred at, that these workers, my lord, have been working, contractors have come and gone, but the workers have never changed. At para 9. Now, these are all undisputed, my lord, even beyond my lord pleadings. It is not something that is in dispute, and I'm also not of the opinion that the management is going to try and throw them out tomorrow. There are 8,000 workers, 4,000 workers, they work for 25, 30, 40 years over there. They cannot be treated in that fashion. So these are the kind of workers that we are talking about, my lord. Para 16 now, please. There was a judgment that was passed by this honorable court, my lord, in single bench, which was subsequently overturned by the division bench. This was in regard to the very same the very same establishment. And is that judgment? I'm only just. It's a judgment where the honorable court ultimately directed that they should be regularized, etc. Of course, my lord, do not remain for high courts to pass this kind of direction. So it was subsequently set aside. But after this order came, my lord, that's when the changes started to happen. So this, my lord, annexure that was issued, which is impugned over here, is something that happened subsequent to the. So in para 16, we have said, my lord, at page 43, please. If I can read from the middle of the page, my lord, I'm going to burden my lord too much. At present, as per the existing conditions of service and employment, the average daily wage of a contract worker is about rupees 750 per day, inclusive of basic DA and other allowances. Not the allowances. But according to the new system, the same worker, if he accepts the new conditions and new terms and conditions, his wage will be substantially reduced, because according to the new system, as stated in the circular, it is seen what is given is a specified work, and a fixed amount is paid to the contractor who fulfills that work. It is up to him to engage the number of workmen to fulfill or to complete the work. How much wages should be paid to these workmen is also left to the sweet will and pleasure of the contractor. The management has given complete freedom to the contractor to exploit labor. This is why we came before this honorable court. My lord, I must draw attention to the statement of objections. My lord, I'm just, as this is the, I think on the last date, my colleague had also handed this over. This is the difference, my lord, in the wages that is going to be received by the workmen. The new contract that they've entered into, my lord, there is an order passed by the learned single judge. The appellant comes before this honorable court, my lord. Interim order is passed on 21/2/2023. They enter into a contract on 28/9/2023. As per the new contract, my lord, this is the difference of wages now for the workmen. Of course, my lord, they have filed a memo where they say that the interim order, because by virtue of the interim order, we have entered into the, we've already entered into a contract. So the matter may be disposed of because it is infructuous. Needless to add, my lord, any action that is taken during the pendency of an appeal is subject to the outcome of the appeal, my lord. So the matter is definitely not infructuous. Now, this, my lord, is the manner in which the workmen are going to be affected. And that is why they went before the Honorable Single. No, my lord, it doesn't. That is the difficulty. On the last date, my lord, my colleague had appeared and submission was made, my lord. Let them say that the conditions of service are not going to be affected. Let them say that, take it on, say that the workmen are not going to be retrenched. That statement is not forthcoming even till now, my lord. And that is why, my lord, the learned single judge, in great wisdom, my lord, felt that it is necessary to protect the rights of these workers, and that order has been passed. Of course, my lord, the judgment that my learned friend has just read, that judgment actually works in my favor. Because paras 8 and 13, what they say is that wages also means wages that are due as per a settlement. My lord, may please see that settlement now. It's with my IA, please.
Yes.
My lord, the settlement starts from page 5. So it's a memorandum of settlement under section 12(3), my lord, of the Act. My lord, may please see para 3 over the page at running page 6. Could I please read that? The Assistant Labour Commissioner, Central Bangalore, with a letter dated 4/6/2018, has initiated discussion conciliation on the matter, and discussions were held between HACWA, which is the respondent, and the contractors, wherein representatives of HEA, well, this is the Permanent Workers Union, and HAL management were present as witnesses before the Assistant Labour Commissioner, Central Bangalore, on all of these dates, wherein the following were requested by HACWA, which is us. My lord, this tradition of HAL representatives, my lord, being part of the discussions is not just this is the first time. Part of the petition, I have placed on record settlements that have been entered into, which are signed by HAL as well as witnesses. So they themselves, my lord, are as much bound by this settlement as the contractors are. But now we have a situation, my lord, where they've entered into a contract. They've entered into a settlement, and this settlement, my lord, is dated 21/10/2023. It's after the agreement with the after the contract. Yes, after annexure Q, after interim order, after the agreement with the contractor. So they are very much bound by the settlement, my lord. If they are going to make an undertaking that the settlement will be complied with, my lord, that at least so far as that concerned, that the matter will rest there. My lord, now so far as the right to be heard, of course, my lord, the contract labor, my lord, somehow are the way, my lord, managements look at them is very unfortunate, my lord. Especially when one considers that these are a permanent workforce. They're doing the same work. Maybe sometimes they're not doing the same work, but they're there for dozens of years. I had the opportunity, my lord, also of representing the sanitation workers in Bangalore, who were as contract labor from 1991 onwards. Subsequently, my lord, in 2017, finally, the state government, my lord, took the decision to bring them under the at least direct payment. They're still not made permanent. But their wages, which was 7,000 rupees, is today 18,000 rupees, my lord. Whereas a permanent worker, of course, still gets around 30,000 rupees. But there are some judgments I want to rely upon insofar as this right to being heard is concerned. The first judgment, my lord, is Lord, National Textile Workers Union, my lord. Here the question that went before the honorable, before the Constitution bench was whether workmen have the right to be heard when a company is being wound up. Until then, my lord, the law that was, my lord, that workmen don't have any right to be heard at all. This, my lord, goes from Tamil Nadu. So with there, my lord, the company judge says that no, workmen don't have a right to be heard. Division bench holds the same. It then goes before the Constitution bench. The Lord may please see, this is AIR 1983, Supreme Court 75, National Textile Workers Union versus PR Ramakrishna and others. Page 1, my lord, running page 5, para 1. The question that was before the court has been set out. These three appeals by special leave raise a short but interesting question of law relating to the right of workmen employed in a company to appear and oppose a petition for winding up. Please, my lord. What was argued, my lord, was that when a winding up petition, my lord, under section 433, that workmen have no say. It is only the creditors who have any say. If I may briefly just para 3, my lord, is the contentions. Finding was, my lord, at para 4, from para 4 onwards. Of course, my lord, the judgment goes into how workmen who contract who give the labor for the company have to be heard. At page 15, my lord. Second line onwards, it is difficult to imagine how any system of law which is designed to promote justice through fair play and action can permit the court to make a winding up order which has the effect of bringing the termination of service of workers without giving them an opportunity of being heard against making such an order. Again, my lord, at the bottom of the page, the same thing is reiterated. At para 11, my lord, page 18, it is summarized. Para 15, my lord. Yes, my lord. And what do the workers want? They want to be heard, that this situation be altered, unheard. They invoke natural justice so as to claim justice. They invoke the same rule which the courts compel administrative tribunals to observe. Can the courts say natural justice need not be observed by them as they know how to render justice without observing natural justice? It will surely be a travesty of justice to deny natural justice on the ground that courts know better. There is a peculiar and surprising misconception of natural justice in some quarters that it is exclusively a principle of administrative law. It is not. It is first a universal principle and thereafter a rule of administrative law. It is that part of the judicial procedure which is imported into the administrative procedure because of its universality. It is of the essence of most systems of justice, especially certainly of the Anglo-Saxon system, that in litigation, both sides of the dispute must be heard before decision, or the alterum partem was the aphorism of St. Augustine, so on and so forth. Next, para 16, my lord. It is said that the Companies Act does not confer any special rights on the workers and they are virtual strangers to the Act. And so why should they be heard in a petition for winding up? The duty to hear those asking to be heard is not dependent on the vesting of any right under the very statute in respect of which jurisdiction is being exercised by the court, but on any right whatever which may come under threat. Yes. So, my lord, my humble submission, my lord, this judgment, there are, of course, my lord, the relevant paras are 6, 7, 8 as well. This judgment emphatically said, even in a winding up petition, workers have the right to be heard, even though the statute does not provide it. Secondly, there's just two more propositions that I want to place before this honorable court. Majority view is this, my lord. The majority view is this. The dissenting judgments, my lord, are by Justice Venkataramanaya and Justice Sen. But the minority, theirs is the minority view. Please, that is the minority. Yes, yes. But sum and substance was because workers contribute to the, and here, my lord, of course, these workers are, Lord, there are a set of judgments I wanted to rely upon in regard to contract labor and the very practice of it. I'm not going to burden my lord too much. Just refer to the paragraphs on that. There are only two decisions which I want to refer to, my lord. Sankar Mukherjee, my lord, where a section 10 notification was challenged on the ground that some of the workers were left out, the loading and unloading workers. Honorable Supreme Court says that they should not be left out. Section 10 should also inure in their favor and they should be made permanent. Of course, this is prior to Air India. But what I'd like to draw attention to is para 1, is para 3, my lord. I apologize. Para 6. This is about the abuse of this contract labor, my lord. And this continues to this day, my lord. This judgment was passed in 1990. The lament of the Honorable Supreme Court at that time stands good today, my lord, if not more, if not equally, in a much more amplified fashion. My lord, the next judgment is at page 7. This is Bhilwara Doodh Utpadak Sahakari Samiti, 2011. This again, my lord, is on the same proposition. I'm relying on paras 2 and 3, my lord, of that judgment. On how the subterfuge of contract labor is utilized. My lord, the third judgment, my lord, which is germane to this case, is at page 10. This is H.D. Singh versus Reserve Bank of India and others, 1985-4 SCC 2. My lord, here a confidential circular was challenged. The confidential circular says that ensure that you make breaks so that these workers don't have continuous service and they do not claim permanency. Just for a moment, my lord, the pleadings, Annexure T may please be seen.
I think all these, I'm sorry, we are not here. We're not discussing the question as to how long they have been working, whether they are being exploited, whether they have a right to be regularized. Now, my lord, these are all issues which have been discussed there. In fact, my lord, anyway, let my learned friend finish, my lord, I'll point.
Annexure T, my lord, page 272 is a subsequent to Annexure Q, is another circular that they've issued where they say this: to the extent possible and wherever feasible, contract laborers should be changed so that continuous service is not established. This is their document, my lord, Annexure T at page 272. That, my lord, in regard to that, it's a very same kind of proposition. What this honorable court holds, my lord, what the Honorable Supreme Court held was that this is an unfair labor practice. At para 13, my lord, page 19, the confidential circular directing the officers that workmen like the appellant should not be engaged continuously, but should as far as possible be offered work on rotational basis, and the case that the appellant is a Badli worker has to be characterized as unfair labor practice. The fifth schedule of the Industrial Dispute Act, so and so. My lord, so this, what is happening, my lord, even insofar as this workers, this Annexure Q, it will amount to an unfair labor practice, my lord, because firstly, the wages that they're receiving, the benefits that they're receiving now are all going to be reduced. Secondly, they, my lord, they also stand the risk of being retrenched. That's why we came before this honorable court, and which is why that order was passed. The last judgment, my lord, that I want to rely upon. The other judgments are there, my lord. I won't. Just the last judgment at page 72. This is a division bench of this honorable court. Preeti Bandege and others versus State of Karnataka and others. Just one paragraph, my lord. The last page at para 12. This is for the proposition, my lord, that you cannot replace one set of contract workers, ad hoc workers with another. From Pyara Singh onwards, my lord, that is the law that has been laid down. So my humble submission is, my lord, by virtue of in these facts of the case, by virtue of the manner in which, my lord, tradition has operated in HAL, this order, my lord, ought to be upheld, my lord, and by the contract that they have entered into, we see, my lord, already how the workers are affected. My lord, and like I said, my lord, the settlement is binding by virtue of the judgment which my learned friend is relied upon. Grateful.
My lord, I have replied. Now, my lord, the issue, as I pointed out here, is whether they have a right to be heard before a contract is entered into by the principal employer. My lord, as I pointed out, their right is only to the extent that existing rights under the settlement are not adversely affected. Now, my lord, this my learned friend has filed. This has to undergo the test because, my lord, these are not admitted facts. These are disputed facts. Now, my lord, a contract has already been entered into now. if that adversely affects existing workers who are members of the union, then my lord, they have a right to go, and that cannot be decided under 226 is my responsible submission. They can proceed. And as I pointed out, my lord, this settlement is binding. The settlement, my lord, is with the contractor. So existing workers, it is not their case that existing workers are removed because of the new contract. It is only their apprehension. Now, my lord, we have also placed it on record, my lord, that it does not adversely affect them at all. Therefore, if it actually adversely affects them, existing workers. Now, my lord, as I read that memorandum. I read that memo that I filed before the learned single judge, my lord, page 457, volume 2. I have said there is no difference at all. Page 457. Other contract conditions, which includes the wages, remain the same. Even when I float the new tender, I have said, my lord, that those tender conditions do not adversely affect existing contract labor. I have stated so in black and white, my lord, before the learned single judge. And therefore, my lord, if there is an issue with regard to some allowance being paid less to a worker who is a member who is already working as a contract labor, it is always open, my lord, to the union or the worker directly to approach the appropriate authorities to seek relief. But that cannot be a precondition to say, whenever you enter into a new contract, I have a right to be heard. Now, my lord, the judgment that my learned friend relied upon in National Textile Corporation case, kindly see, that is between the employees of NTC and NTC. That is not pertaining to contract labor. Now, my lord, an employee who is directly employed by NTC, that, my lord, the Supreme Court says he has a right to have his say with regard to winding up proceedings or any other proceedings that the employer intends to take. Now, my lord, what is the relationship between the contract labor and the principal employer? My lord, kindly take this judgment of the Supreme Court, which I filed in my compilation. Steel Authority of India. Now, my lord, that concludes the issues, my lord. My learned friend read to your lordship, Singh and Shankar, all that, my lord, for various reasons. But then, my lord, everything has been considered. And then, my lord, please see at page 70, para 120. One minute.
Yes.
Para 120, my lord, if your lordship sees. Yes, my lord, they are not my workers at all. They are not my employees. They are employees. But then, my lord, I must ensure that the provisions of Contract Labor Act are complied with. Therefore, if they are not my employees at all, what is their right to say whenever I enter into a contract, they have a right to be heard? The NTC judgment will not apply because of this. In fact, my lord, in a subsequent judgment, my lord, where at one interesting aspect also may I point out, my lord, at page 6, if your lordship takes, page 6 of my compilation. This is between BHEL and Mahendra Prasad Jamola. This is again pertaining to contract labor, my lord, where the issue was referred for adjudication.
Yes.
And, my lord, the labor court records a finding that the contract is a sham because of various reasons. One of the reasons was that they have been employed for a number of years, for 15 years, though the contractor changed the
contract labor continue to be the same. And then, my lord, they were being issued gate passes, various other factors. Now, my lord, the Supreme Court applied the test of supervision and control, which was applied in Bahadur's case. And ultimately, the Supreme Court reversed a finding of fact of the tribunal and then said that the finding of the tribunal that the contract is a sham is not correct. And the Supreme Court allowed the contract labor to be continued on that basis. ಇದನ್ನು ನೋಡಿದ್ರೆ even that, my lord, on those grounds, my lord, the Supreme Court reversed the finding regard to that. Therefore, here, my lord, this is not a case where, my lord, a violation of a settlement has been pointed out to say that the new contract violates terms of a settlement. The settlement that has been entered into between the contractor and the workmen and the contract labor represented through the contractor, that does not provide that whenever new contracts are entered into, if principal employer will give them an opportunity of hearing, that does not say that. Therefore, I have not violated any terms of contract between him, though I am only a witness in that. But then, my lord, as I pointed out, so long as that agreement is in place between the contract labor and the contractor, now, my lord, employees who are covered under that settlement shall be paid the entire wages and emoluments which are covered in that. My lord, that I have already said that there is no adverse impact on that. So,
Yes.
My lord, I
and
don't
this
wish-
is not a proceeding under section 10, my lord, where your lordships are going into.
I don't want to join
Questions of
issues, my lord,
fact.
but there are two judgments of the Honorable Supreme Court. The Constitution judgment in Basti Sugar, where it says that emphatically contract worker also are covered by the employers, and Hussain Bhai's judgment, my lord, where it says that if you have the power to take away the employment of a person, then you, for those practical purposes, are the employer. Those judgments may also be grateful. Grateful, my lord.
Twenty-one, Urgeshwi Charity.
I seek an adjournment in this matter. Yes, yes, yes. Yes, it's quashed. Preliminary. Yes, your lordship. Yes, Reshma Devi. I'm not sure of that. Yes, your lordship. Different. Yes. Notice as to who? Yes, but notice is not yet ordered. Respondent number 1, ma'am. I take notice for.
Twenty-two, Mukanappa SB.
Just. But also, as a matter of fact, Reshma Devi has been informed of the case. And maybe no reason to. Not be a reason to. The lordship, even otherwise, certain considerations have to be taken, whether in fact it is the same facts or not. Because there is no reasoning in that judgment. So one that has been tell us. It only follows Reshma. Yes, it only says election. Yes, yes, that's already visible. The facts are. Yes, and we need not labor issue to this. It is the same notification, same notification. Everything else is the same. Same, yes. But we should bring them on record without please tell us. Yes, yes, yes.
23rd. 22, Mukanappa SB.
This has been served to respond. Nobody will file the respondent.
Colonel Single Judge, my lord, the HR rate. HR rate is advocate for arbitration. Note has been served,
Yes.
but nobody.
And appeal.
Yes.
Yes. Show the name of.
And also permit me to serve the copy of the.
Yes.
Twenty-three.
Please.
Please mute. My lords, may please permit me to cite a certain compilation of case laws which I have filed. There, my lords, I want to point out only a certain issues. My lords, I have given I leave it to the discretion of this court.
Please. Please.
Please, as and when, my lords, please.
ಹೌದು, 18. ಆಗ್ಲಿ.
Please,
Please, please, oblige.
please, deeply obliged.
Twenty-four. Ravindranath.
My lords, I appear for the respondents, my lords. I seek for short accommodation, my lords. Senior is not keeping well, my lords.
Who appears for the appellant?
Appellants, I think, my lords, Chandrikala, my lords.
Ravindranath K.
Probation, my lord. She was on probation. She's discharged from service on the ground that certificates produced by her do not cover rural education, rural qualification.
My lords, I seek for short accommodation, my lords. Grateful, my lords.
25. Sorry, HR.
Speak by UGC, my lords. Yes, 15 days. The notice has not gone, my lords. Yes. Ma'am. May also be, yes, ma'am. I may also be permitted to serve it on the panel counsel and counsel appearing for the petitioner in the writ petition, my lords. In addition to that, I may be. Yes, ma'am.
Respondent number 9, state takes notice.
Respondent number 10, my lords, Mr. Sunge is here. He is appearing for case, connected matters, he has appeared, my lord. I may be there. Respondent number 1 to 8, my lords, I may be permitted to serve in addition to taking steps to the council.
R10 ಅವರಲ್ಲ open university.
Yes.
R9 government. 26. Rajendra Kumar Singh.
Lord, this appeal filed by the university, my lord, Karnataka State Open University is an appellant hearing, my lord. And it's the order of the learned single judge.
No, 27 they have. 27 they have. Okay, sorry. Degree certificates, admission prior wasn't received.
Yes, my lord. My lord, yes, yes. Lord, there are, Lord, this is a university established by the state government.
Tell us what happened to election. E-F&G judgments.
I've attended finality. There's no any appeal.
No, no, my lord, I had come to that, my lord. Annexure E, my lord. My lord, those are the students, my lord, there are two things here. This university, my lord, this is open university established with the state. There is two modes of admissions, my lord, for the for the university. One is a student who comes directly to the university and gets admitted. And we have, my lord, in the districts, my lord, we have regional centers. There also, my lord, students can go there and admit. It's called, my lord, in-house students. They are called as in-house students. And the other mode, my lord, of course, it is not there now as of now. In those days, my lord, other mode was, there was an MOU, my lord, entered into between the university with other collaborative institutions situated, my lord, toward India, even outside the state, my lord, or India. And then, my lord, yes, my lord, India, then, my lord, those students, they used to admit. And, my lord, there is a sharing of the fees, my lord. And we used to issue a degree. My lord, what happened in this particular case is, my lord, the courses which were, my lord, the university had earlier had allowed those academic institutions to have their own study centers, in the sense the small in the colleges or whatever. They would have in turn have a MOUs, and then they would authorize the other small centers also to take admissions and send it to the accommodative collaborators. They in turn, my lord, they used to send it. The courses which university used to offer, my lord, is the normal courses, BA, BSc and all those things, my lord, BCom and all those things. Whereas the MOU says, my lord, even the technical courses, even, my lord, to the extent MTech, technical engineering course and other courses were also allowed, my lord, by the MOU. My lord, when it was, UGC has noticed this, then, my lord, UGC said, you are a distance education university. No, Lord, nobody can acquire the professional or technical degrees through a distance education, because there will be they would not attend the classes, my lord. It's only a distance education through degree, my lord. BSc IT, my lord, information technology. It's a technical course, my lord. BSc information technology, my lord, unless you have a practical, my lord, knowledge of this thing, my lord, they cannot give any degree in the IT. Yes. Yes. Through the study centers, not directly. My lord, in all other cases, EFN, my lord, all other cases are the students who are directly admitted to us, my lord, directly admitted to the university. And there, what happened, my lord? For those students, my lord, during 2012, my lord, up to 2012, university, UGC had a recognition, my lord, for this university. Then in 2015, a public notice was issued saying that because of, by narrating all these anomalies, say that your recognition is not continued. The UGC has issued a public notice. Yes. Yes, madam. Yes. Yes, madam. Yes. Yes.
Till 12-13.
Yes, my lord. There was an institutional recognition. Yes.
Hello, third para is important. Third para is same notification, page 45.
Yes, till then, till 12-13, did have the
Recognition.
Yes.
Therefore, the question, where the has not been raised and it has not been considered by terms of justice. Where have you raised it? Where do you say that there are persons who took admission differently, that they are not? Discussion, what is the contention?
No.
Such contentions are available. Now, all that let me say that till 2012, we had persons who go before that will not be covered by that public notice, the withdrawal of all that. What that is all that is being found by the that only says the right of the other practices. UGC has categorically submitted that in the other filed by the AAA.
Yes. That is filed by us only, my lord.
Yes. Whoever has filed it.
Yes.
UGC has and including film year 12.
Yes, madam.
Would be entitled to get their degrees. This immaterial as to when they're actually completed. The finding.
Lord, this is,
Dated 18/8/2021, the said letter report from being prospective and not not having impact.
this has been filed by me and my lord. In fact, I as the council, my lord, we only have filed on behalf of the university. What happened was, my lord, after this 2015 public notice issued by UGC, my lord, those who had acquired degrees from the university, they applied, my lord, for various posts, my lord, in employment. Even for KPC state public, lord, this thing also they have applied. Then they started rejecting, saying that, but because 2015 onwards, my lord, it was not recognized. They said your degree is not recognized and all. Then, my lord, there was a lot of, my lord, students sake and everything. Then, my lord, because in the meantime, what happened? The state government has constituted a committee consisting of a former chief secretary, my lord, chief secretary, look into the interest of the students and take some decision. Then state government, what they did, my lord, in 2013, they have said, the students who have been directly admitted to the universities and who are the residents of Karnataka, who have been directly admitted, their degrees can be recognized. Those, my lord, who have,
I'm sorry for the intervention, my lords. If your lordships goes to page 53, my lords, appeal memo in the petition filed by the appellant, in the first para, my lords, they have sought for a declaration I may be permitted to read para second. KSOU has filed this writ petition seeking for issuance of a writ of mandamus, directing the second respondent to consider the candidature of the students who have obtained degree awarded by the petitioner university for all its recruitments.
Yes.
Say that the state government has said that it is only persons who are directly enrolled.
Yes, madam.
Where is your pleading this?
No, I have said, my lord, I just point out, my lord. Para 8, my lord, of my appeal. My appeal, my lord, appeal memorandum.
Yes.
The appellant submits that though it has been specifically contended that the convocation or degree certificates have not been issued to the students who have completed their courses through study centers, academic collaborative institutions under the open and distance learning mode, in view of the issue of public notice dated 16/6/2014 by Annexure C issued by the UGC, and has justified the action of the appellant in issuing the impugned endorsement dated so and so. However, the learned single judge of this honorable court, relying on the judgments referred to above, has followed the said writ petitions, quashing the impugned judgment. It is submitted that the facts and circumstances of the cases which has been referred by respondent number 1 has no application to the case on hand, as Srimati Snehalata and Manoj pertains to non-technical degrees, that is MA, BA, obtained from the appellant university as in-house candidates. My lord, this is what I want to try. Whereas the respondent number 1 herein was a candidate admitted to a study center through an academic collaborative institution, for which there is a total bar by UGC to offer education through study centers for academic collaborative institution, which were established by entering into MOU by the appellant university. That apart, the GO dated 5/3/2018 and the corrigendum dated 3/5/2018, the state government has recognized the degrees obtained by the students who are admitted through in-house program directly to the appellant university for the academic years 2013 and 14 and 14 and 15 have been considered as valid recognized degrees entitled for a higher education, employment, etc. But in the instant case, the benefit of the said government order is not applicable to the petitioner respondent number 1 herein, as he was a student admitted through a study center and not the in-house student. Hence, the learned single judge ought not to have.
12/13 till 12.
Institutional recognition, that's true. Yes. No, but yes. No. What UGC and the Supreme Court may not
I'm
say.
asking for UGC, just one small clarification. This particular. No,
UGC.
UGC, I'm asking for the UGC.
No, 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 no. My contention is that this BSc IT, although it's a BSc IT degree, it cannot be considered as a technical degree. It has been held that it is not a technical degree. So therefore,
Thank you.
Now they say if it is a technical degree, it's not the authority.
Yes, sir, it's AICTE.
Although it is a BSc IT, it is an information technology degree. So therefore, it may not be considered as a technical.
Editor Lodge. But those judgments may not, that pertains to the inner students, what and single judge has referred.
Yes, still 12 after.
Yes, yes.
12, distinction
Yes, ma'am.
between in-house and out.
Yes.
Recognized is the standard in UGC.
If the,
It is recognized. So,
if the UGC has no objection, madam, they cannot have, we cannot have, because normally, my lord, the UGC, yes. Yes, yes. That was called institutional recognition.
I'm also a panel counsel for UGC, my lords, in those matters appear. So let it not be that the UGC, even before, my lords, 12-13, my lords,
There is a bar.
technical course should not have been offered, my lords, even prior to that, the recognition was given, there were certain courses that are offered. Because before that, there was a scheme wherein UGC, AICTE and erstwhile Distance Education Council, they used to recognize whether a particular technical course should be offered or not. So my only concern is lordship may not observe that until then, even technical course should have been given. It was not there.
attention is not taken.
It is not even taken, and that was also not a position, my lords. Here, it is not a technical.
Have been considered.
Considered.
So learned secret that proceeds on the basis that it is a.
Up to 2000.
Yes, sir.
And that after 12-13, everything else, your contentions, even in your appeal, only go to show that after 12-13, that is from 13-14 onwards, it could have been, there was differentiation between persons who directly.
Admitted and
Direct admissions and others. So then, all these are matters if you had such contentions. It's a basically
It appears the objections has not been filed before the single judge.
what happened to the other judges?
No.
Sure.
We are, my lord, in fact.
Lords, Chief Justice has passed and not dismissed. Similarly, MSc IT was the course which a student has undergone, my lords. In that, my lords, the single judge's order was appealed by KSOA, my lords, and the single judge, Chief Justice Division Bench has dismissed the appeal at the threshold itself, considering that it is not applicable.
The prayer is similar prayer. It is
Similar. I will give this.
Yes,
copy. I will give.
the petition number.
I will have, now give it.
No, let them furnish, my lords may kindly proceed to
I'll-
pass an
I'll-
order. It may not be any problem. Yes.
Yes.
Yes, I'll give it.
Pass.
Number.
Tomorrow.
W. Writ appeal W. 116 of 20. Based on record, we can probably replace
We'll do it.
Yes,
We'll place them.
Tomorrow.
27.
No, lords may kindly proceed to pass an order, my lord, without listing again, my lord, why it's not.
Tomorrow. 27 urgent, 28.
Lord, my learned senior has first right of audience, my lord. Yes, my learned senior has first right of audience, my lord, I'm not saying. But one objection we could not file inadvertently, my lord, it remained in our, the only limited submission, my lord, that I would make before my learned senior begins, is that the writ appeal was originally filed challenging the impugned order. And my lord, the contention was taken by us by filing a IA saying that the order passed by the learned single judge was under Article 227 and not under 226.
So there is no appeal remedy available. Now, my lord, that contention was, according to me, conspicuously missing in the original writ appeal filed. Therefore, my lord, learned senior filed an application adding new grounds and, my lord, the certain other facts. To that, my lord, I am filing an objection. And my specific request, my lord, and prayer before your lordships is, let that issue be first taken up. That whether, my lord, by way of an amendment, whether a new case can be made out, whether it is a new case, or, my lord, learned senior has right to, my lord, bring in the facts which are in consonance or coherence according to him with the writ petition. Now, my lord, this is one prayer, my lord, is that objection I have just now served on him. That application, my lord, is to add additional grounds, and the additional, yes, in the writ appeal. And there is also, my lord, I filed, this arose because I filed preliminary objections along with an affidavit raising the specific contention that under 227 there is no appeal remedy. Lordships may that is, my lord, 6/2/23, that is before your lordships. After that, my lord, this application was filed, to which, my lord, I may be permitted to file objections. And, my lord, let that application may be, my lord, heard first, is my prayer, subject to, my lord, lordship's consent and subject to, my lord. Because if at all it is not added, yes. Otherwise, my lord.
So it was understood after, this has come several times, my lords, before several benches. It was understood that it would be heard finally on merits of the case. If my learned friend wants that to be decided, I have no difficulty. I'll address arguments on maintainability of my writ appeal. But since
First time before your lord.
I realized. Now, therefore, my lords, if my learned friend wants that to be argued first, to be honest, my lords, since it was understood that we are addressing the arguments on merits, today I got prepared only on merits.
My
What
fault.
I have it any day after tomorrow, any day, I will address on issue of maintainability first, and then.
Great.
No, any day convenient to the court.
In the meantime, I'm also, my lord, there is one judgment referred there, just a one-page judgment, my lord, of the Honorable Supreme Court, just one-page judgment, which says, my lord, that valuable rights accrued in favor, sir, madam, valuable rights accrued in favor of a party before amendment cannot be altered. That is why, my lord, I am praying. No, this is widely followed. The proposition, my lord, the widely followed, and I will also, my lord, buttress arguments with the first principles also or other judgments. Now, this is, my lord, the limited proposition that I am making is, if your lordships were to allow that, it will change the complexion of the appeal. And, my lord, that issue cannot be gone into because the original writ appeal was not filed, my lord, with that premise and that contentions included. If your lordships, my lord, we are at your lordship's hands. Correct, please. The petition. Yes. Yes. And the order also, my lord, whether at all, even though the learned single judge has said it is 227, whether it is 227 exercise or to that, my lord, I bow down. But pending that, lordships may consider this also as a, my lord, issue. Because if the amendment is not allowed, then, my lord, my learned senior will have to argue on the main matter, divorce this application. If it is allowed, then, my lord, the amendment has to be brought about to the writ appeal, and, my lord, that will be heard.
Yes.
That's good.
30th.
What?
30.
Great.
30th is Monday.
29.
30th.
Renuka HR.
Respondent will. She is not feeling well, my lord. Respondent. Appellant, advocate not feeling well. Delay may kindly be condoned. Yeah. Fine. Yes.
Date में गए नहीं date और admission में date
30. Government advocate.
Lord, in this matter, my lord, by order dated 19/7/2023, there was a direction to file a better affidavit, my lord. It's being listed only now after that date. Please, my lord, there has been, my lord, this is a case where 78 is the grant is what is claimed by the respondent, my lord. In 2010, when suo motu proceedings were initiated by the Assistant Commissioner, a report was given by the Tahsildar that there are no such grant records available in the office with respect to the land which is being claimed by the respondent as granted land. Thereafter, Assistant Commissioner passes an order that is confirmed by the Deputy Commissioner. The land is allotted to the Fire Department, my lord. Subsequently, the respondent challenges it before the KAT and the order is set aside. And the learned single judge also holds that there is no provision to initiate suo motu proceedings, my lord. But my submission is that there are no records, my lord. Even the original records, there are 2 entries, my lord, with respect to the same survey number. 2 entries. One entry is with respect to the respondent and there is another entry with respect to another person. And also, my lord, secondly, that it is a sarkari katte. Since it is a katte, that means it's a tank bed and it could not have been allotted to anybody is the case of the state, my lord. I have been directed to file a better affidavit, my lord. After that date, there has been no communication. I shall do so, my lord. It may kindly be called after 23rd or it may be called on 30th, my lord. After 30th, please. Obliged, my lord.
Yes, that's what that's. 14, 10. 31, Satish K.
My lord, this matter, my lord, my colleague is not keeping well. Since Saturday, it may be called on tomorrow, my lord. He shall be present and he shall argue the matter.
Yes, yeah.
Day after.
Hearing on IS, number 32. Nagendra Naik.
my lord, we are for appellant.
83 days. This has to go.
Yes. Notice.
Council notice has to go. Delays, there's a delay. Yes, issue notice.
33.
There also delay. Notice.
Okay.
I
Recalling
filed-
order.
Delay in filing the IA for recalling.
Yes, there is, it says that if there's a delay in filing LR application, it actually should be delay in filing the appeal. That is filed, your lordship.
The- Notice has to go. IA recalling order dated 7/11/2022. There also there is a delay? No,
There is a delay.
there is a delay. Issue notice in the delay petitions.
Yes, yes.
34, Ravi Shankar Sia.
Appellant, is a delay of 120 days.
Lords, I appear for the
Taking
response.
notice,
My lords, I filed objections.
your objections are on record. 126 days
Yes,
in filing in IA 1 of 24. What is filing delay in the appeal?
Filing delay in appeal, my lords, but
Can be condoned?
my lords, the affidavit may kindly be seen, my lords, there is no designation of the officer.
Because your lordship, after getting the commercial court's order, I sent to the head office, your lordship. That is the only, because company is taken and also they approved and get it and also pay the approved court fee.
He's,
Because I am a defendant, court fee. That's why, lordship. That is why we have taken the same road. We can't take the other similar ground to the, as well as the independent person.
Lords, the designation of a person who is swearing the affidavit and whether he is
I
authorized
am
or,
working as the appellant company.
please, my lords.
Please say what the designation is at least. When you're filing an application before the
I'll
court,
say,
the details must be there. Who is he?
definitely.
Because when it is so and so presiding at Bangalore, I'm working
give
as the
the-
appellant company. Please
Please.
make the corrections in the affidavit.
Made
Yes,
they
I will
gave an
make it.
undertaking before the trial court to pay the amount.
Then they file.
Undertaking, because it is a challenging order, before we also contested, and there is no liability at all.
That we'll consider, but please
know.
at least make the
2 weeks.
necessary corrections.
I will make an
Yes.
other affidavit also.
Yes, learned counsel for the appellant seeks time to place a better affidavit on record
Yes, Your
in
Honor.
support of IA 1 of 2020.
I will file it.
Yes.
Much obliged.
Just after 2 weeks.
35 urgent, 36 urgent, 37 Kalpana PV.
36.
36 adjourned by somebody.
I don't know, Lord. I
Morning,
have not been
10:30.
informed. It's a commercial court matter. My lords have
Yes.
said it should be heard. The other side won't have taken much.
Was
on
it?
Next Monday we have it. 1 week only there.
Can be.
But at least they should have mentioned it.
They should have, definitely. I normally make it a point to ask whether I was told that the other side has been told. Not in, that was in 35. Nine.
Okay, please.
There's a delay, my lord, notice has to be.
This is in 37.
That's
Take notice.
38 Natraju,
Again, notice. Delay of 74 days.
39 Ajesh Kumar S.
My lord, for the appellant, my lord.
Here for the respondent, rest 2 weeks time to file objection. On the day itself, I am ready to submit the argument.
Lord, there's a blanket order of stay. Why have come before my lord? My lord, my vendor, my lord, sold the property to me. Even according to him, my lord, I have paid all the sums due. His case is that I made some payments delay. Based on that, my lord, he files an application under section 9 to say that, please,
There's already an interim order.
my lord, my difficulty is, my lord.
What is the order?
The order says that I should not sell any part of the property. I'm developing it to put up an apartment building.
Next week.
My lord, can I just point out?
Your lordship,
One
your,
submission, my lord. One submission.
your lordship kindly see, they are legally obliged and liable to pay 31 crores
That is what. we are
under
con-
the registered sale date.
This is what
they
we
are
are
due.
considering. Please place your objections on record. We'll consider
One
it.
submission.
May-
One
Yes.
I'm afraid to
My lord, they,
weeks time to file objection.
they send me a legal notice, my lord, which is at ink page 102. At para 9, my lord, they specifically say this. Finally, your company has paid a sum of rupees 62 crores so and so by, that's at ink page 105, by way of demand draft bearing number so and so in respect to the dues towards the sale deed dated 19/7/21. Similarly, your company has paid a sum of rupees 26 crores so and so by way of demand draft bearing so and so in respect of the dues towards the deed of transfer of possession dated 19/7/21. My lord, by this they admit the entire amount of payment under the agreements which I owe them. Then, my lord, at ink page 165, they themselves agree that the time for payment has been extended. According to them, my lord, there's a delay of 2 months, where, my lord, most respectfully, the trial court falls in error. Trial court, my lord, in its finding at ink page 59, says that the first amount should be adjusted towards the interest, thereafter towards the principal. In generally, my lord, I would have agreed with the proposition. But, my lord, the contention of the applicant before the trial court is that I have received the entire money. What is due is 2 months, according to me. According to him, it's 8 months. My lord, the trial court could have told me, my lord is pleased to see 120 crores is the transaction. I have taken a 115 crore loan from the bank. The plaintiff informs the trial court that we are developing the property, we are putting up apartment buildings, we have got permission from the Real Estate Regulatory Authority. Therefore, the trial court is conscious. And they, my lord, fairly ask for 2 relief. They say either restrain them from selling the property or giving them a security. What trial court says, my lord, by its order, I think page 63, till the disposal of the arbitration proceedings.
You're
Now-
willing to furnish security for the entire amount of the claim?
My lord, their claim, my lord, most respectfully, even according to them, would be around 2 crores, my lord.
Whatever.
I
that-
will furnish the security for 2 crores, my lord.
My lord,
Furnish security
not
for
ready
that
to-
claim.
they are not ready.
Whatever be the,
My lord,
whatever
but
that be.
I know what's falling for my lord. My lord, I am developing this land to put up apartments.
Furnish
30
security.
I can-
31 crores
What I'm
amount
saying
is
for my
due.
lords, can I sir, one.
No.
My lord, what I'm submitting for my lords, till the arbitral tribunal is constituted, which would be fair as per section 9 of the Arbitration Act. My lord, I am putting up an apartment building. I will say that 10 apartments or 15 apartments, my lord, in this building
because I have more than 500 customers. I'm under RERA. Those 10 or 15 apartments, which would cover this value.
No, what exactly is the injunction now?
Injunction says, my lord, by an order of restraint from creating any third-party rights in respect of the scheduled property. Entire blanket. That's my difficulty.
31 crores amount is due.
That
and
cannot be.
31 crores.
31 crores.
It
Under
provides a
registered
limit for
sale
31
date.
crores till the arbitral tribunal considers the section 17.
And so by giving apartments, my lord, I will file an affidavit.
What is the stage of the construction now?
My lord, it's just, it is started now, my lord. It is, as even according to them. Even according to them, I.
Therefore, non-existent
27,
apartments,
22, my lord.
non-existent apartments may not be, as of now, security cannot be in non-existent apartments. You must provide some security which is acceptable.
120 crores paid.
Till
No.
Still the tribunal is constituted and the tribunal can take up the
No,
section
that would be
17.
only.
That's
two
all.
crores.
No, no.
Why I'm saying.
31
Well,
crores,
that requires a hearing.
My lord,
We'll
most
consider
respectfully,
this.
my lord,
31 crores is
Can I
due.
just say this,
Under
my
the
lord, for my
registered
lord's
sale
time?
deed,
My lord,
since
for my lord's time
2021, they are not ready to pay.
My lord, for
Up
my
to
lord's
this day,
time
they are not
justification.
furnished any surety.
Council, please don't make submissions together. Point is that you have to be heard.
My lord, my
Yes.
most respectful submission is rather than a blanket statement, my lord is pleased to have it tomorrow. I will take instructions from my client and I'll just place a memo of calculation to show to my lord.
Memo of calculation business, we cannot consider at this stage. What we are saying is that you must provide security for the claim that he is making. That is all.
Can my lords have it tomorrow, my lord? I will make a submission.
Yes.
15
Serial number 8. On people are stuck up, they wanted some password, they opposed it. Artists have posted up on 23rd. Problem I'll tell you, Lordship. We have, they owe us 347 crores.
Yes.
They are dissipating the properties. In fact, one asset, they have dissipated. So any earlier date, subject to your Lordship's can be. I'm sorry, I owe an apology. I owe an apology, to your Lordship.
17. Also we have.
Because what has happened is, let me tell you, Lordship, why, my Lord, I am mentioning this. I am now prevented from, my Lord, exercising any right, including filing a suit or, my Lord, the NCNT proceeding. Therefore, my Lord.
9.
Grateful, but I'm sorry, profound apologies.
May I just request for immediate, either on 11th month, if it's 11th, just request. My lord, some inconvenience we had, that is, no objection for an earlier date, only request is 11th.
Please.
Change. Orders 2:30 PM, seal number 40. Yes, Mallikarjun.
I appear for the appellants in
Claims 9, 12 and 15 are reported to be dead. I have filed LR application to counter, my lord. Claim number 9, 12 and 15 reported to be dead. 9, 12 and 15. And I have filed application, LR application regard to appellant, but already filed in the registry. And remaining, I want 1 week to ascertain the date.
my lords. I appear for the appellants in the connected matter, 40.1. I request my lords to dealing this matter, my lords, and list it separately. The reason is, my lords, in fact, on the previous occasion also on 23/3/2023, my lords, this honorable court, my lords, had ordered to dealing the said matter. But however, in the.
No, that is, my lord, the order, the second writ appeal, it was followed the order of the first order passed in.
Yes, my lords. Lords, in the next week for final hearing, my lords. Yes, my lords. On the last occasion, my lords, my learned friend submitted and connected it. That's the reason. No, my lords. My grounds are entirely different from the grounds charged.
No, same land, my lord, and the in the second writ petition, they have followed the order passed in the first writ petition, then that was disposed. So, see.
My lords, I have some urgency in this matter, my lords, since that is the, what has happened in this matter, my lords, the neighboring landowner, he has encroached my property. I'm in the possession of the property. I filed a civil suit for injunction, my lords. Trial court granted an injunction. Against that, they came and appeal, my lords, before this honorable, before the single judge. The findings given there, my lords, since your acquisition is still under challenge and is still kept under consideration, injunction cannot be granted because your title is still under consideration. Now, my lords, because of that, I have been rejected of injunction. Now, my lords, they're putting up construction. If they succeed in putting up construction, I'll be putting.
There even the Supreme Court also rejected their claim, my lord. Thereafter, this is a second round, they have filed the writ petition. First round, the Supreme Court also rejected their claim.
This may be heard, my lords.
Yes.
The next week, my lords, finally.
17.
Yes.
Obliged.
Meeting 41. Yes, Sachin.
May.
Well, its matter has to be taken up for hearing, Lords. Office objection is only regarding, my lords, filing of
Synopsis.
synopsis.
Written submission.
Yes, my lords, sir. Otherwise, matter was taken up, my lords, even on the last occasion.
It is.
We are ready.
very
I'm ready with the
short matter. Could you lords kindly consider looking at the order sheet dated 23/4/2025, where the court has already expressed. It's the order sheet, lords, of your lordships, dated 23/4/2021. At this stage of preliminary hearing, in the presence of my learned friend, lies in a very narrow campus, my lords, as to whether the examiners were duly qualified or not. So if your lords are inclined to take it up for hearing, lords, I would like to submit it.
Take it up, provide this. Thank you.
Lordship pleases, my lords. Subject to your lordship's convenience. Lordship. Yes.
Forty-two, Ganapati. Forty-three. 43, V Vachan.
Hearing on behalf of the respondent number 2 and 3. File the. Therefore, a short accommodation to file synopsis. I have to also file the short synopsis, my lords. I'll have it next week. Status quo order may kindly be extended, my lords.
44,
Oblige, my lords.
Shiv Prasad Shantangowda.
With your lordships kindly, my lords. On the last date of hearing, my lords, it so happened that in this case, the lands of the petitioners were, acquisition was called in question and went up to Supreme Court and it was set aside, my lords. Now it is sandwiched inter se between two pieces of huge land acquisitions that are initiated by the board for industries. He had filed a petition seeking for an access route through his land. Then its single judge was pleased to allow it. We have filed an appeal and even he has filed an appeal calling in question a portion of it. I had undertaken, this honorable court, my lords, on the last date of hearing was pleased to direct us to file an affidavit providing the access way. My lords, the affidavit is ready, bound for approval. My lords may have it next Monday, I'll file. My lords, there are two appeals. In one of them, I am the appellant. In one of them, he is the appellant.
Please.
Monday, my lords. Please, oblige.
45, Harish Bandari.
For responding. Request a week's time to comply.
My lords, there one submission, my lords. On the last occasion, in the presence of respondent itself, Honorable Court has granted the interim order, my lords.
Regarding
Considering the same, directed to post the matter in the usual occasion, my lord. Usual course, my lords. Kindly matter may be posted for the final order.
final hearing, it may be posted, my lords, and in meanwhile, I'll. Yes.
46.
Recalling the to recall the order, subject to complaint within the time frame. Complaint will appear as summer left out. Each of my friend is foundation. My.
47.
My lord, my colleague is getting the synopsis, my lord.
But in fact, it was substantially heard, my lord, then he's.
My request for a date, my lord, my request for 10th.
Date, my lord.
17th.
70 for hearing.
It's all our senior citizens.
I'm ready, my lord.
In the
Synopsis.
saga of this litigation, many of the owners, they died. They are represented by their legal representative.
My lord, 17, 230. 230.
Yes. 48.
Oblige, my lord.
My lord, for the appellants, my lord, I pray time of 1 week to do the needful, my lord. To issue notice to R3, my lord.
49. Mohammad Tahir.
Translated copy of the annexure.
For the respondent number one. Much obliged.
50. Yes, Venkat Subra.
They seek dispensation of notice to Article 9. Yes, my lord, they were set ex parte, my lord, in the commercial code.
There are other notifications, have they been complied?
They're compliant, my lord, insofar as the process being taken. R1, I will not file within 1 week. Yes, more, my lord, but seeking dispensation. All of them. They were similar, they remained ex parte before the commercial code. The presence may not be. More, my lord, than that.
Very
51.
My lord, for the appellant, my lord, I request.
I'm appealing for KVA to respondent number 5, my lords. We have not been served copies, my lords.
We'll comply, my lord. May I request, my lord, if I comply in 2 days? My lord, if I comply, may I request a date, my lord? I'll comply in the next 2 days, my lord.
17.
70, grateful.
Grateful.
Ravi Kumar BR.
IA number 3 has been filed for extension of time. I have deposited 10 lakhs. I need a weeks of time to do the needful of another 15 lakhs.
Lordships,
Weeks time, my lordship. I'm asking just weeks time.
it's already been 3 months now.
7/6, the order, interim order was passed. Yes, much.
Date, Your Honor.
17.
Interim order may be extended, my lordship.
17/9.
Much obliged.
Much obliged.
Much obliged.
Yes. 53. Navi Daman.
In this case, I appear for the respondents counsel, my lord. This is the proceedings under the eviction proceedings. He has delivered the possession to me. Now, my lord, he is liable to pay 2 crores and odd towards the arrears of rent. The matter itself can be closed, my lord, if he pays that amount. He has been taking time to file memo of his.
Memo of
I have
calculation.
been, I have
Last date
filed
I
all.
had mentioned, I have to file the memo of calculation. Memo of calculation is ready. As accordingly, if the security deposit is delayed, minus, then the outstanding amount will be 37,88,000.
No.
Please,
May I make one
I will
submission, my lord? May I
please.
make one submission? May I make one submission, my lord? Let this memo of calculation be referred to the mediation, my lord. Let the mediator take a decision as to what is the exact amount due. Because I am
Counsel,
disputing.
the memo, if the memo is served on you, can you not look into it and arrive at a decision here? It will be made available to you.
Very
Yes.
well, ma'am. Thank
Learned Counsel to serve a copy of the memo of.
And I'll file it in the registry. Your Lordship.
Yes, file it in the list. Yes, list after 10 days.
Yes, Your Lordship.
Yes,
Please.
ma'am.
Much obliged.
23 to be filed in the registry.
Some date may can be given. ma'am. Date may.
9.
23.
54.
Much
Shilpa
much
Rani.
I'm appealing by the appellant, my lord. In this case, my lord, can you have 2 weeks time, my lord, engage senior counsel, my lord. Brief for the
Maintainability.
maintain interim order, my lord. We have challenged it, my lord. In this case, petitioner is ready to settle the amount, my lord. If it is referred to the mediation also, we are ready, my lord. The only condition which is not considered, my lord, that is I am eligible 40% of the shareholder, my lord. Is my trial court, my lord, ordered to pay the 50% of the amount, my lord. My share itself is a 40%, my lord. Hence, I have filed this appeal, my lord. I am ready to settle my 40% of share. I am ready to settle it, my lord.
Yes, unless maintainability is decided, I would issue notice. Issue notice to the respondent subject to the question of maintainability.
Please.
Yes. If you are willing to settle, then that may be the end of the matter. We may not have to consider maintainability at all. Yes.
55.
Union of India
Chandrachud.
maintainability. What is this?
My lord,
the office has raised an objection stating that this suit is, the original suit is disposed of by the court of the district and sessions judge. My contention is that it was a works contract. So lordship, without wasting your lordship's time, I'll directly draw your lordship's attention into one paragraph in the judgment itself, which says that internal ink page number 17 of the judgment, page number 40 of the paper book, Your Honor. May I draw your lordship's attention to paragraph number 15. With reference to the first claim, it is the specific case of the plaintiff petitioner that the arbitrator ought to have awarded the claim as claimed in the, is based on a work done at, it's a works contract, Your Honor. It was jointly measured and recovered by the petitioner and the respondent engineer in accordance with clause 6 of the standard general clauses. So SCC and GCCs are involved.
But the court was not a designated commercial court.
Lord, in Mysore, it is considered by the principal district and sessions judge. So my respectful submission is that in one of a similar matter of this nature, this honorable court.
It was under section 34.
Yes, my lord, it's under 34. So commercial appeal is maintainable, is my.
Whether it is an MFA or commercial appeal which is maintainable would be the question.
Yes, my lord. That's the only simple question. It's a short question. My contention is I have filed a commercial appeal. The office has come to a conclusion. It should have been MFA, not commercial appeal is my understanding. That is the office objection, what they. And it's an arbitration suit. Yes, my lord.
Maybe so, but if the subject matter of the arbitration is not a commercial.
In one of
then
the
it
similar.
becomes an MFA.
In one of the similar nature of cases, when an RFA was filed, this honorable court was pleased to consider the same based on the objection raised by the other side, that it should be a commercial appeal.
Was that again a matter which arose from the principal district judge?
Yes, my lord. The learned counsel for the respondent has filed a memo seeking transfer of the appeal to commercial appellate division of this honorable court, as the matter of the appeal is a commercial dispute coming within the ambit of Commercial Courts Act 2015. Though the learned counsel for the appellant objected for transfer, we find no reason to accept the same on the ground there is a force in the submission of the learned counsel for the respondent in terms of section so and so of the commercial dispute means a dispute arising out of an agreement for goods, sale of goods. This is an agreement which is for works contract, Your Honor.
Yes, issue notice to the respondent subject to the objection of maintainability raised by the registry.
Lord, I have gotten, now it has been remanded back for fresh consideration. Maybe when it is considered, when the consideration is before your lordship, if the arbitrator again freshly opens the matter, that's why I've sought for an interim order, because it's been remanded back for fresh consideration. May I read the operative portion?
What was the date? When was it remanded back?
It was remanded on 25th April 2024, Your Honor. Award passed by the arbitrator, award passed by the defendant number 2 arbitrator is set aside. Consequently, matter is remanded back to the arbitrator to consider the documents of the plaintiff in the light of the observation made in the judgment.
Till the next date of posting, subject to the objections, if any of the respondent as to maintainability, the further proceedings shall not be precipitated.
Deeply obliged.
Till the next date.
Yes, madam.
56, Sio Kerala.
Yes, for petitioner's counsel.
This is a matter where, my lord, last
Before my
occasion.
learned senior starts, my request for a copy, my lord. I requested for a copy when they moved the matter, after they moved the matter. On Saturday itself.
There is no caveat.
There is no caveat, but when they moved, my lord, I told them, my lord, I'll appear, please give me a copy of it. I'm aware, my lord, that there's no caveat.
Can we pass this over?
My lord,
Can we pass this
please, my
over?
lord, very well.
Let
Please
your
have
lordship,
a
it's
copy.
anyway against an interim order, non-grant of interim order.
No, so what?
Very well.
No, I have a right of
Very well.
audience.
I'll
How
just
can
have
you
a look
control
at-
the court?
Yes.
I'll have a look at the paper.
Tomorrow?
Very well.
Please.
Great.
Yes. Please serve a copy.
Please.
This will take some time. This will also take some time. Shall we finish up the department matter? All this.
call 57, let us see. Bill number 57, final hearing. V.S. Prasad.
This is a Lokayukta matter, my lord. This
Yes.
relates to this locus standi of the Lokayukta to challenge the order rejecting the sanction.
Yes,
My lords,
Um,
before can I make a submission? my
yes,
lords?
please.
I appear for respondent 2 in 6822 of 2015. There are two matters.
Yes,
In this matter, respondent 2, we have engaged service of Mr. Nagbhushan. Today is having some inconvenience, but my senior advocate may go on, my lords. We will place our arguments next week, my lords.
let us start
Huh.
the arguments next week. Is that not better? Hmm. No, we'll decide the issue, and then that will, if the question of maintainability is decided, then the. No, we don't have to decide in every single case. We only have to. Exactly, counsel. The question of law can be decided so that all the others will probably be governed by the decision on the question of law. Yes. No, instead of having piecemeal arguments, senior counsel.
yes, my lord. There are two issues. Your lordship may kindly recollect one batch of matters. Your
Yes,
lordship
yes, yes.
to 22nd. Those are the matters where we are generally our locus standi to challenge matters relating to tribunal orders.
Yes.
The present case is where the Lokayukta police, locus standi of the Lokayukta police to challenge the rejection of sanction order.
Yes. Can we consider it next week? Because
Very
the
well,
respondent
very
is seeking time. Instead of
Very
piecemeal
well.
arguments, is it not better that we,
Very well, my lord. Yeah, it can be heard together.
along with the other matter? Yes.
Very well.
21.
Grateful.
Yes.
Rising out of same issue.
Hmm.
One interpel is the main matter.
Hmm.
But if there is not, there is no interim order. Is that operation of it. So we make submission on all those, that the matter is seized by the order.
Yes, and it is listed for,
We will not press note any interim order. But I'll not see.
Yes. Please, because it is, we are hearing it on the 21st. By the way.
Great.
Hmm. Passed on matter, number 7. Serial number 18.
Lord,
Yes.
in respect of the second part of my rejoinder, Lord, in respect of the dichotomy between a finding that my contract is concluded insofar as the arbitration clause is concerned, but it is not for the purposes of merits of the matter. Lord, my first submission in respect of an error of jurisdiction, and I have tried, my lords, to put it in brief in that written note. In error of jurisdiction is, Lord, my first submission is it was nobody's case, and my learned friend has confirmed through the course of his arguments that it was his case that there was no contract at all. And it was my case that there was a contract. Therefore, the error of jurisdiction is, it is a question of fact whether a particular clause within a contract can be considered as if it were agreed independently is a question of fact. Neither of the parties put that fact before the Honorable Tribunal. For that matter, neither of the parties argued it that way. Therefore, without pleading, without evidence, without argument, the tribunal comes to a factual conclusion The second question, my lords, is such a conclusion permissible in law? Because if it is permissible, then I have no legs to stand on. My lord, if your lordship will kindly see para 75 of the award. In this portion of the award, lord, howsoever fair a reading one may give of the award, there is no reference to section 16 of the Arbitration Act. I tried, my lords, to see if some other section number is quoted merely as a typographical error. In my respectful submission, my lords, even if one were to strain oneself to read it fairly, the tribunal has not considered 16, the tribunal has considered section 8, which just does not apply. Your lordship may please see para 75 onwards. In para 75, there is reference to section 7 and section 16. Then your lordship may please come to, and that is recording the submission of the respondent. Then para 77. Parties made elaborate arguments at the time of section 8 application. My lords, now section 8 just does not apply here. 8 applies in the context of a suit.
Typographical error.
So, notes, I started by saying I tried to read it as if it were a typographical error. That does not appear to be so. I will point that out. Then, my lords, your lordship may kindly come to para 78, second portion. At page 114, if I may read, Arbitration Act, in short, Act. Before touching upon the merits of the matter with regard to arbitrability, let us see the provisions of the Act for proper appreciation of this issue between the parties. Section 8 of the Arbitration and Conciliation Act provides for power to refer parties to arbitration where there is an arbitration agreement. Therefore, it is not a typographical error. The Honorable Tribunal has considered 8. They have not considered 16 at all. Then, my lords, para 79, once again, last but one line, last 2 lines of para 79. What cannot be forgotten is that what is required is an agreement in terms of section 8 of the Act for the purposes of arbitrability of the dispute. Once again, my learned friend is saying it is 7 or 8. My question is, it was a 16 application. Then, my lords, case law is copiously extracted. Some of the case law does refer to section 16. But your lordship may now please come to para 84, which is the conclusion of this part. There is reference to case law until then. In my respectful submission, my lords, why I submit that this was actually a reference to 8 and not to 16 is para 84, the last 6 lines, if your lordship will see, where the conclusion is to this extent.
84.
Para 84, page 55, my lords. The last 6 lines from top did intend to resolve the disputes between the parties in terms of Exhibit C1. Full stop. To this extent.
Cannot be paragraph. Oh, there are 2 paragraphs, 2 84s.
Oh,
Yes.
I'm so sorry.
Yes, because there is an earlier paragraph 84 as well.
Yes.
That could be an error because after 80.
Lord, that previous 84 is an extract from a case law at page 50, at page 115.
Sorry. Yes, 84 is at page 118.
Please, my lords, 118, page 84. The 6 lines from bottom, my lords, is where the ratio is, or the finding is, did intend to resolve the disputes between the parties in terms of Exhibit C1.
Yes.
To this extent, C1 can be considered a concluded contract. The words thereafter, my lords, assuming that concluded contract is a necessity for arbitration as argued by the learned counsel. Lords, the Honorable Tribunal makes this error because section 8 does not ascribe finality to a decision. It's only a prima facie view. This is inspired by that prima facie view that assuming it is needed, because section 16 is just not applied, and my lords, para 84 begins with reference to section 8. Therefore, this tribunal has to find out as to whether this arbitration is covered in terms of section 8 or not. Now, my lords, let me assume against myself. In my respectful submission, my lords, even a fair stretched reading will not say that 8 here means 16. because there are three provisions. There is 7, there is 8 and 16. It is hard to decipher in what context it is 8, in what context it is 7 and 16. Those are the only two relevant provisions, not 8.
This may kindly see paragraph 83.
Just
Yes,
a moment.
83.
Yes.
83, my lords, begins with section 7. Courts have considered section 7 of the act and courts have ruled that a tender form. That is para 83. Therefore, my lords, if that is so, if the tribunal knows that it is 7, then this should have been, I don't know whether this is 8 or 16, be that as it may. There are only, lords, I ask myself the question, when did the tribunal pronounce a finding on whether this arbitration clause is an independent arbitration agreement under section 7 subsection 2, or is it a part of another larger contract? Is there a finding? There is no finding at all. Your lordship may kindly see, my lord, section 7 subsection 2 for a moment.
Yes.
An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Now I ask myself the question, should there not have been a finding on this when somebody questions the arbitration clause? There is no finding. The reason being, my lords, the moment there is a finding, that finding is overwhelmingly in my favor. In this case, it was not the case of either of the parties that it is a separate arbitration, that it is a separate agreement clause contained in a contract. Now your lordship may kindly say, my lord, section 16, whether the test in section 16 is even prima facie applied, irrespective of which number is employed in the award.
Yes.
The arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to existence or validity. Therefore, existence the tribunal can rule on. And for that purpose, a legal fiction is created, my lords. For that purpose only, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. Then B, my lords, the separator is and. Therefore, B also has to have a play. A decision by the arbitral tribunal that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. But section 16B has been completely not considered. It is not a case of wrong consideration. It is a case of non-consideration. So also the commercial court.
Yes.
What's here? My case, very simply put, is in 16A, it says an arbitration clause which forms part of a contract. Therefore, notes the moment there is a finding that there is no contract, then section 16B comes into the picture. I am not saying, my lords, in all circumstances B will prevail over A, but it comes into the zone of consideration. In this case, the question is, the tribunal says no contract was formed. Lord, when no contract is formed, my respectful submission is there is no agreement. It is not even a case of a contract. There is no agreement at all because the parties have not come together to make up their mind on what they are agreeing. And that is the case set up because they say under section 7 of the Contract Act, there is no unqualified or unconditional acceptance. That's the finding against me, that the board has not agreed. If the board has not agreed, there is no acceptance of the contract. Therefore, there is no agreement at all. If there is no agreement at all, then courts have said severability principle is just not engaged. It is not relevant. It becomes relevant when after there is an agreement, the contract either becomes void or is voidable. For instance, my lords, mistake of parties, the contract becomes void. On this point, my lords, there are two decisions of two high courts. In my respectful submission, my lord, very instructive judgments. In fact, one of the decisions is by the Honorable Chief Justice of India now, sitting in Bombay High Court. it is, and I will show, my lords, from the 7-judge bench decision that similar findings are there even in the 7-judge bench decision. And with this, I will conclude these 2 judgments and the 7-judge bench decision. What's my learned friend was saying, concurrent findings. If there are no findings, or I can't, in 37, tribunal has not pronounced a finding on this matter. In fact, my lords, if I may put it this way, the tribunal has not paused to ponder about this question at all. That is there a dichotomy, such a dichotomy permissible in view of section 16(1)(b) is a question that is never posed. Wait a minute, not copy.
It was my objection.
Mine.
Before the tribunal, I had raised this objection, and paragraph 85, the court had taken notice of a judgment which I had cited. But anyways, the tribunal applied the severability principle and said that we can.
Yes. Not para 46 may kindly be seen. We may now formulate the essential features of doctrine of separability. These are:
Yes.
the arbitration agreement constitutes a collateral term in the contract which relates to the resolution of disputes and not to the performance of the contract. Whereas the substantive terms of a contract define the rights and obligations of the parties, an arbitration agreement provides for the modalities. Parties agree thereby to have their disputes resolved before a tribunal as distinct from the ordinary courts of law. 2. Upon termination of the main contract, the arbitration agreement does not ipso facto or necessarily come to an end. The issue as to whether the arbitration agreement survives or perishes along with the main contract would depend on the nature of the controversy and its effect upon the existence or survival of the contract itself. If the nature of the controversy is such that the main contract would itself be treated as non-est in the sense that it never came into existence, or the arbitration clause cannot operate, for along with the original contract, the arbitration agreement is also void. Similarly, though the contract was validly executed, parties may put an end to it as if it had never existed and substitute a new contract solely governing their rights and liabilities thereunder. Even in such a case, since the original contract is extinguished or annihilated by another, the arbitration clause forming a part of the contract would perish with it. Then clause 6, your lordship can please see. The doctrine of separability requires for the arbitration agreement to be null and void, inoperative or incapable of performance, a direct impeachment of the arbitration agreement and not simply a parasitical impeachment based on a challenge to the validity or enforceability of the main agreement. In other words, arguments for impeaching the arbitration agreement must be based on facts which are specific to the arbitration agreement. This, my lords, is respectfully a crystallization of the law division bench. My respectful submission is that Roman 4 squarely applies to the facts of this case. When if the tribunal comes to the conclusion that the main contract never sprang to life, so also the arbitration. If the board did not approve all other terms of the contract, the board also did not approve the arbitration. Therefore, this dichotomy, with utmost respect, is contrary to, squarely contrary to law. And the decision of the Madras High Court on similar lines. That is there in the list of authorities that I have already. It's here. Thank you. Para 43 onwards is the relevant portion. Para 36, your lordship may please come to. Survival of arbitration clause when the main contract perishes.
Yes.
The conclusion that the arbitration agreement is severable from the main contract does not automatically mean that it would always survive the main contract. While the arbitration clause need not always follow the fate of the main contract, of which it is a part, the corollary that it will always survive even if the main contract perishes cannot be taken to be true. Therefore, in order to find out the circumstances under which the arbitration agreement would survive the main contract and the circumstances in which it would perish along with the main contract, we may have to take recourse to the provisions of the Contract Act. The Contract Act, among others, deals with valid and enforceable contracts, voidable contracts, contracts which are void from their very making, and contracts which were enforceable from the beginning. Then your lordship may please come along to 39 directs.
Yes.
The question as to whether an arbitration clause would survive a contract of which it is a part, like a lifeboat in a sinking ship, does not arise at all in respect of the first type of contracts, namely valid and enforceable contracts out of which disputes arise. The question about the survival of the arbitration clause dehors the survival of the whole contract, arises only in other three types of contract, namely voidable contracts, contracts which are void ab initio, contracts which became void after a period of time, frustrated contracts. So then your lordship may kindly see 41 because 40 is in respect of voidable contracts. Insofar as the third type of agreements, namely agreements which are void ab initio are concerned, the ability of the arbitration clause to survive the whole contract is doubtful. Suppose an agreement is entered into between a person in India and a foreigner, whereby the foreigner agrees to supply arms and ammunition to an Indian citizen who holds no license for such imports. Such an agreement would be hit by Section 23 of the Contract Act. The agreement would be void ab initio, and hence the arbitration clause contained in such an agreement would certainly survive the main agreement. To hold otherwise would tantamount to permitting an arbitration into the rights and liabilities of the parties to the agreement, out of which no such rights and liabilities ever flowed, nor could ever flow. Therefore, if an agreement is void ab initio, the arbitration clause contained in such an agreement would not be a lifeboat in a sinking ship, but a lifeless boat in a ship which never commenced its operation.
Yes.
The last is, if your lordship will kindly see my note, I have referred to 3 paragraphs of the 7-judge bench decision of the Honorable Supreme Court. In the majority opinion itself, there are certain observations to this effect.
Yes.
If your lordship will just kindly see my lords, footnotes number 101 and 102, as footnotes number 5 and 6. Those are page 4 of the note. Just the footnote.
Yes.
Para 101 and 112. But
Yes.
your lordship may please see from the notice. However, Gary Bond points out that although an arbitration agreement could be separated from the underlying contract, it can never be independent or autonomous from such contract. This is largely due to the fact that in certain situations, the defects in the underlying contract could also invalidate the arbitration agreement. The separability presumption further ensures that the invalidity of the underlying contract does not affect the jurisdiction of the arbitral tribunal to decide on the nullity of the contract or any other issue submitted to its jurisdiction by the parties. Then, unless it finds that the defect which causes the nullity of the contract affects also the arbitration clause itself, The last sentence of Article 16(1) extracted above states the general principle of contractual validity of arbitration clauses. It connotes that the invalidity of the underlying contract will not necessarily entail the invalidity of an arbitration agreement contained in the contract. Accordingly, the arbitral tribunal's jurisdiction will be affected only when the defect causing invalidity is directed at the arbitration agreement. Then 265, invalidity of an underlying agreement may not, unless relating to its formation, result in the invalidity of the arbitration clause in the underlying agreement. This, my lords, is a formation case. In both the two leading judgments, my lords, of the Honorable Supreme Court, the 7-judge bench decision in Interplay and the 5-judge bench decision in Cox and Kings, the Honorable Supreme Court says one must look at laws in especially jurisdictions like Singapore and India and Indian law, and I've extracted those portions here in the notes, and that Indian law must develop in patterns, if permissible, of course, within our statutory context, in similar lines, because ultimately our arbitration law is not just domestic, it is also international arbitration law. Therefore, it applies to the world at large. English and Singapore courts have consistently held in formation disputes, the severability principle is not engaged. The severability principle comes from Article 16 of Ancestral Model Law, which is identical to Section 16 of the Arbitration. I ask myself the question. All of this not considered by the tribunal, not considered by the court. If it is not considered by the arbitral tribunal, should that not be reason enough for the award to go? What's my submission is, just like how the tribunal came to the conclusion that there was a valid arbitration clause, the moment the tribunal pronounced that finding, it had no jurisdiction thereafter to examine whether there is a concluded contract or not. Because in this case, the severability principle is not engaged. The tribunal had to adjudicate my matter on merits and award damages, which is exactly what the minority award does. The commercial court also, my lords, does not consider these aspects of the matter at all. In one paragraph, the commercial court says there is severability principle, therefore it is separate. The commercial court asks the question, saying they stand or fall together. That is the term employed by the Singapore courts. It is recorded, but there is no finding. Therefore, my lords, neither at the stage of the tribunal nor last submission, Your Honor, fact says, the Lordship may kindly note just the date of the statement of rejoinder, statement of objections filed by the respondent. Multiple arguments have been made on multiple occasions that because of my action, they could not proceed further. Unfortunately, it's a lie, nothing more. The statement of objections was filed in 2021. 17 January 2021 is the date of statement of objections. At page 276, my lords, of the convenience compilation. In the statement of objections, a submission is made. The lordship may just permit me not to show those two paragraphs say that their entire case of prejudice is with respect to a false case.
Page number?
Page number, lords. Your lordship may please come to 253. 253 of the convenience compilation.
Yes.
This is not filed before the tribunal by the respondent.
Hmm.
In the statement of objections, this is dated 17/1/2021. The lordship may please see para 3, my lords. The claimant approached the respondent in or around 2011 for a space with relatively no potential competition in the vicinity, period of 27 years on completion, and was completed in the year 2014. The multiplex of the claimant is at second phase, which is still incomplete The occupancy certificate of second phase is received only on 31st December 2019. Respondent is yet to receive door number of the same. Thus, I am still not ready to commence operation. Now, your lordship may please see page 272. Last two lines of para 28 at page 272.
Yes.
Last two lines, my lords, remains operative thereafter. It is therefore clear no temporary injunction was in force after 15/2/2020. In para 3. So he says temporary injunction is not there after 15/2/2020. 2021, door number is still not there. And my lords, assertions are being made that because of an interim order, they had to undergo some damages. Not the only person who has suffered is me. From 2011 to 2019, they never raised the issue of board resolution. They took money from me after the agreement. When they took money from me, they did not ask me, did your board approve it? They received the money. They called me. I engaged with their experts. I helped them make the drawings and designs so that a theater can be built there. The day they had an alternative offer, they made an unreasonable demand of me and then they terminated. They have not suffered any damage as a consequence of my action. They have not filed a counterclaim. They have not filed a suit. It was a contract for 27 years for them. But I am saying, please permit me the opportunity to have this adjudicated on merits, because today, my lords, I am left in a Trishanku situation. There is an arbitration clause, but there is no concluded contract. I have not had a finding on merits. That is my expectation.
I'll just take 5 minutes by watch because I understand, my lords, I have finished. My lords, the case, my lords, was based on the ground that BTS is a concluded contract. And his argument before the tribunal and the pleadings as well as the evidence which he has laid was that there was an express board's consent, there was an express communication of the board's approval, and therefore BTS has a concluded contract. That was found by the majority judgment to be not correct. There is no board's approval, and the tribunal by majority therefore said BTS did not form a concluded contract. It was not their case that BTS, that the acceptance was not expressed, but acceptance was by subsequent conduct. That was not their case.
It is my case.
No, it is not your case. I'll point out from pleading.
I'll just read out page 280 is the requirement of confirmation of board approval of the claimant is only a procedural formality and it does not have any binding effect on the BTS.
Millers, please read paragraph 9 of the rejoinder. Please read that, where he says very clearly that BTS does not require any further consensus ad item. Please read that. And in the paragraph 5 of the statement of claim, I read out all of those paragraphs. Please take your seat now. Please don't interrupt. I did not interrupt. In paragraph 5 of the statement of also claim, he said expressly that he said that we communicated the board's approval. That when we had pointed out, he in the rejoinder, he said, okay, that's only a formal requirement. But he again goes ahead and says BTS does not require further consensus item. BTS is a concluded contract. And his argument, when he argued the matter before the tribunal as well as before your lordships, he argues that, well, so what if there is such a condition? It is for my protection. It is for as a shield. That was the first argument which he had made. And even if there is no board approval, that will not take away the fact that BTS is a concluded argument. Which is why the tribunal was focused only on that question as to what would be the board's, what is the, if there is no board's approval, whether BTS will stand concluded or not. Which is why the entire focus was on that. Now, I am very surprised, with great respect, to the dissenting judge. he gave an entire opinion, my lords, on dissenting opinion, but in his, my lords, dissenting opinion, there is not even a passing reference to this requirement of board's approval. He does not at all deal with that clause. Whereas, my lord, that forms, my lords, the main argument. In absence of board's approval, whether BTS stands concluded or not. Now, I'll just give an illustration, my lords, and with all humility, please do not take it otherwise. I'm assuming, my lords, that the High Court on its administrative side, perhaps, my lords, entering into contract for upkeep of these computers, this TV and all of that, on the administrative side. Now, let us assume a situation where the registrar, my lords, of the High Court, he enters into negotiation with a service provider. He enters into an agreement which is styled as BTS. And in that, he discusses all the rates, applicable rates, and the future, how it's going to be increased. Everything is set out in detail. But also, he adds a clause in that BTS. All of this is subject to the approval of Chief Justice. He also says that all of this will form part of an agreement in future, which will be entered into subject to satisfaction of A, B, C conditions. Now, till the Chief Justice, why does he do that? Why in this case that company officer has done it? Because when he goes before the board of directors, or when the registrar goes before the Honorable Chief Justice for his approval, he wants to take some concrete proposal. The Honorable Chief Justice may say, sorry, I don't agree with this. You go and enter into fresh negotiations. He may also say, no, he may just keep it aside. He may say, well, this can wait. You finalize those drawings and other things which you have discussed. All of this can wait. You go ahead. Till the Honorable Chief Justice gives an approval of the BTS, and till such decision is communicated to the service provider, can the service provider on the basis of the BTS say, well, High Court is bound by it. It is a binding contract. That would lead to great respect. I don't want to use those expression. It will be very wrong. It will have serious consequences. Which is why, my lords, where in a matter like this, where the dispute is about the formation of the contract, we have to adjudicate this dispute by applying the first principles of formation of contract. Was there an unequivocal, absolute, unconditional, unqualified acceptance or not? If it is not, there is no acceptance. Which is why I cited the judgment where the English courts have said that if a company officer says, I'll tell you, Lords, why in this case, what could have happened? Because the company, the office, somebody at Kerala, Kochi, was entered into the negotiations. That man does not have the authority to bind a contract because the head registered office is in Delhi, and it's a global company, so there may be some other headquarters somewhere in Mexico or somewhere. Just I'm giving an example. And I'll show you why. Because his witness who had signed this contract did not come to before the tribunal. The person who deposed, he was specifically asked this question. Just kindly have this in that place. Whether this person who had signed the BTS, did he have authority of the board or not? He said, I do not know. Please have this. So I understand a situation, my lords, where perhaps the service provider had said, so what of the Honorable Chief Justice approval is not there, but under the standing rules of the High Court, the registrar is empowered to take such a decision. That can be possibly a case. I'm just assuming. They have to show that the person who signed the agreement even otherwise had the authority of boards of approval. They could have said that, but in any case, I am not. That has to be communicated. The other side has to be made known. Because how does the other side know what is your internal guideline and all that? But just kindly see the question which was put to the witness. He's just kindly have, my lords.
Apply to rejoin them.
No, you went ahead and argued so many things. Just please see, my lords.
The applicant.
Please see page 475. Cross-examination. Do you work under Mr. Deepak Mada, signatory of Exhibit C1? He is the signatory. At the relevant time, he said yes. Question number 35. Question number 36. Would it be correct to say that Mr. Deepak Mada, despite being the managing director of the claimant company on the date of BTS, did not have the authority from the board to enter into the concluded BTS? He said, I do not know. He said, are you privy to any of the communications between Deepak Mada and the board of directors before or after the signing of BTS with regard to the BTS? I do not remember. Do you remember? So these are the questions. So he has no idea if the signatory had authorization from the board of directors to even sign the BTS. Which is very important, my lords, in a case like this. Now, my lords, with great respect, just give me that. Note. Yes. The other argument, my lords, which my learned friend made was about, my lords, the separability, the arbitrability argument. Now, my lords, it is, I have, my lords, I wholeheartedly accept the arguments which he has made that if there is no binding contract, then there is no arbitration agreement. But unfortunately, can he make that argument? I have not challenged the award. It was my case before the tribunal that, look, because there is no binding contract, therefore there is no arbitration agreement. It is he who went before the arbitration agreement saying that there is a binding contract, there is also an arbitration agreement. He dragged me into this arbitration. He elected the forum. The tribunal did not agree with us both. It took the middle path and it said that, look, I apply the separability, that there is a concept of separability. It relies on Enercon's judgment. And it says that, well, this agreement is valid, but then it on merits, it found that there is no binding agreement. I did not challenge it. Can he now challenge the finding by saying, if you have found that there is no arbitration, there is no binding contract, you should have also held that there is no arbitration agreement. Can that argument he make? I did not challenge the award on that ground. I did not make a challenge to the order which was passed on my Section 16 application. Section 16 was decided in his favor. How can he, my lords, take that argument? Then, my lords, your lordships may see that, my lords, on that, he is saying, my lords, that entire arbitration award should go. Just for a moment, my lords. Please see, I had before, my lords, he started all of this, I had entered into with a contract with a third party. Third party is not a party to the arbitration agreement. And, my lords, there is a specific contract with him in the statement of claim. Just kindly have a look at the prayer. There is a prayer in the statement of claim. Please see prayer BC. To pass an award that the alleged leave and license agreement with Carnival Films Private Limited is illegal and invalid. Now, Carnival, I have already entered into a contract. Carnival is not a party to this arbitration agreement. Carnival was not included in the arbitration agreement. So to allow his relief of specific performance, your lordships will have to first hold this to be illegal because Carnival we have already entered into. The construction has gone on. In the result I have given in detail that I've made construction on the basis of designs provided by Carnival. In fact, Millers, today, as of now, the multiplex is operational also. It is operating. Now, so the tribunal says, and I'm just that please see this, just kindly come to the tribunal's finding at Milord's paragraph 135. Please see paragraph 130. Just Milord's wait, sorry, just before 130. What is that? Page 130. What is this? Yeah.
Paragraph?
Yes, para 134. Just take this.
Yes.
Page 144.
208.
Admittedly, Carnival Films Limited is not a party to the arbitral agreement. The claimant has not chosen to initiate any acceptable legal remedies against Carnival Films Limited, and Carnival Films Limited is not a party before us. Learned counsel for the respondent while opposing this plea refers to a judgment of the Honorable Supreme Court in Vidya Drolia. This judgment supports the respondent. The prayer is therefore granted on the face of it. Now, what does Vidya Drolia says, Milords? I'm just producing, Milords, the relevant paragraph which I had relied on. Because Vidya Drolia, if our lordships remembers, Milords, is a case on section 11 on Milords whether arbitrability, what all disputes can be considered arbitrable disputes for reference before the tribunal. And then certain categories of case, the court found that, sorry, if there's something like this, the subject matter of the disputes like this is a rent agreement or something related to where only criminal courts will have jurisdiction. These are matters which the tribunal cannot look into. So there cannot be any reference even under section 11. At Milords, in this judgment at paragraph 48, there is it says a judgment in rem determines the status of a person or a thing as distinct from the particular interest in it of a party to the litigation. And such a judgment is conclusive evidence for, sorry, Milords, I should be reading paragraph 49. Sorry. Exclusion of actions in rem from arbitration exposits the intrinsic limits of arbitration as private dispute resolution mechanism, which is only binding on the parties to the arbitration agreement. The courts established by law, on the other hand, enjoy jurisdiction by default and do not require mutual agreement for conferring jurisdiction. The arbitral tribunals, not being court of law or established under the auspices of the state, cannot act judicially so as to affect those who are not bound by the arbitration clause. Arbitration is unsuitable when it has erga omnes effect. That is, it affects the rights and liabilities of parties who are not bound by the arbitration agreement. Equally, arbitration is a decentralized mode of dispute resolution is unsuitable when the subject matter of a dispute in the factual background requires collective adjudication before one court or forum. Certain disputes. So here you have sought cancellation of a lease and license agreement with a third party, with whom I have already entered into a third party. So therefore, the tribunal says, sorry, I cannot grant you these reliefs.
Yes.
Just said 4 sentences.
Just 1 minute. I have not completed. Then just on section 16(3), Miller, section 16.
Yes.
Kindly have Miller section 16. My learned friend read my lord section 16(1). The mandate of an mandate of an arbitrator shall terminate and he shall be substituted by, yes, competence. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence and validity of the arbitration agreement. And for that purpose, the arbitration clause, which forms part of the contract, shall be treated as an agreement independent of the other terms of the contract. This is the severability principle which the tribunal applies. Next, he said, a decision by the tribunal that the contract is null and void shall not entail ipso facto. He says it in conjunction with A, he reads B, and he says that both of them should be present. He said, and a decision by the arbitral tribunal that the contract is null and void shall not entail ipso jure the invalidity of the arbitration agreement. My lords, in this case, the clause B is actually, my lords, in the nature of an explanation of clause A. Because what happens if supposing the tribunal says, well, the contract is null and void, like in this case, supposing the tribunal says, well, I find that there is no binding contract. But if it automatically also means that the tribunal has no jurisdiction, then what happens to the reasonings given for the arriving at a finding? Because the tribunal, like a court, when it gives a finding on jurisdiction, that the court does not have jurisdiction, it will record certain reasons. The court will record, these are the A, B, C reasons for which we find that the court does not have reasons. Can you tomorrow say that the court once it has said that it has no jurisdiction, then all those reasonings also get washed away? That cannot be an argument, because a court which is deciding the jurisdiction point is within its competence to give all findings with regard to its jurisdiction. I hope I am making myself clear. If your lordship says that, if your lordship is called upon to decide a question of jurisdiction, your lordships have the competence to go into the facts and determine whether the court has jurisdiction or not. And those findings, as far as parties are concerned, the parties are bound by those findings. Because it's a matter which relates intrinsically to the issue of determining jurisdiction.
Yes.
It is for that 16(3) says, kindly have a look at the section again. That section 16 makes it clear. A decision by the arbitral tribunal that the contract is null and void shall not entail ipso jure the invalidity and arbitration clause.
Yes.
It is for that purpose, because the idea is to keep to distance the arbitration clause from the underlying contract. Now, I did argue before the tribunal that, look, once you have found, because I argued for this reason, that if you look at the commercials, which he is referring to in Appendix 1 of the BTS, the arbitration clause is located in the Appendix 1, which has to be incorporated in a future contract. Which is why my submission was that because BTS itself was not a concluded contract, there is no question of these relying on these clauses in the Appendix 1. That is how I formulated my argument.
Yes.
With that, I leave it. I would like to argue, my section, that other matter, again.
I just thought in
Yes.
about 6 sentences respond to my learned friend. What my learned friend says, the tribunal has to decide its own jurisdiction. I have no dispute. All I am saying is, once the tribunal in para 84 says, we see that all features of a contract are present here. Therefore, this is a valid contract. The tribunal cannot go back on that finding. The tribunal is bound by that finding. The tribunal had to give me an answer on merits by holding that the contract is concluded. Maybe the tribunal could have said, I've committed breach.
Well, just
The
one or
tribunal
two.
could not.
Yes.
But
I'm
the
sorry.
tribunal could not have said there is concluded contract for the purposes of arbitration, but for all other clauses, there is no concluded contract. That respectfully is a startling conclusion. Then, my lords, my learned friend said Vidyadrolya, that the tribunal could not have gone into the question of third party rights first. That is not what the tribunal said, because if the tribunal had said that, the tribunal should have told me, in line with Vidyadrolya, please go file a suit. This matter is not arbitrable. Lord, there is a world of difference between arbitrable and presence of arbitration clause. The tribunal did not say that.
Tribunal said we refuse to
My
give,
learned
grant
friend
that
should keep
prayer.
quiet now.
Yes.
Third, my lord, my learned friend says, this is a relief for specific performance. Today he has been a little selective. There is an alternative prayer for damages in 50 crores. For that, certainly no third party is necessary. The minority award says I am entitled to damages. Therefore, the dispute that I brought is most certainly capable of adjudication. Maybe the tribunal will say you are not entitled to specific relief, which is what the minority arbitrator said. But the minority arbitrator says there is a breach of contract on the part of the claimant, therefore you are entitled to damages, but does not compute the damages for him because he is in the minority. Then perhaps my learned friend read out portions from the cross-examination. It is not for him to support the reasoning here. It must be found in the award. The award is silent in all of this. All that the award, and that is my complaint. All that the award does is award says is there a board resolution? No, sorry. Without considering any other material, which perhaps is patently erroneous, was vital evidence of the parties. So many questions my learned friend points out. I am not saying they are irrelevant. I am saying they are relevant. I have also asked questions. They are also relevant. None of them considered by the tribunal. That is the error that vitiates the award. Because the award focuses only on 2 sentences in the contract without appreciating how the parties understood. Then, my lord, my learned friend says that the minority award does not deal with the board resolution. I'm a little surprised. Your lordship may kindly see page 164. I will just read one paragraph of the minority award and I will conclude. The minority award considers it, in my respectful submission, considers it most appropriate. Subclause C at page 164. BTS is entered into on 27/9/2011 and from September 2011 till 23/9/2019. That is nearly for 8 years. At no point of time respondent has raised any issue as to requirement of approval of Board of Claimant Company. For the first time, such a contention is raised in its letter dated 23/9/2019. That is only after the claimant refused to agree for changes to be made in BTS as per the request made by respondent in its email dated so and so. What is not contemplated between the parties for 8 years, suddenly after a lapse of 8 years, and after acting on the terms of the BTS, it cannot be said that an approval became essential after 8 years. That apart, claimant company is not disputing BTS between it and respondent. There is no objection from anyone in the claimant company. Parties never contemplated the approval of board is an essential term of the bargain, which is otherwise clear from the exchange of emails and conduct of the parties, which shows that both parties accepted and agreed and acted upon BTS. D, the division bench of the Karnataka High Court in a judgment, I will just read the portion of the judgment. The offer of the appellant subject to the approval of the board and lender was not a condition precedent for formation of contract. They were conditions for the benefit of the appellant and could be waived by the appellant. This is not considered at all. Grateful.
Yes.
Millets
on-
I have written submission. I'll file them in that.
Yes.
Or I can.
Now let's on this, Millets, on this.
Not my prayer, I put it in writing also, is that the award must go. And once the award goes, the entire cost of the respondent must be paid to me. That is the entire 84 crore, 84 lakhs.
The damages were not proved at all. There's no discussion on damages. Anyways, Millets, that. Now just Millets on this. What are you reading? What are you saying? Huh? Okay. Very well. Now on my Milord's appeal, kindly have a look at Milord's, the award, the section 34 judgment. Milord's, kindly have a look at the award. Yes. Kindly have Milord's. Yes. Let's just before Milord's, I just start this.
Just
one.
a moment, in
Yes.
this appeal, have you submitted the written?
Milord's, I have the written arguments. I'll place it on record.
Please do.
Yes.
It's already filed in the previous appeal.
No.
New appeal.
It is here, Milord's. Milord's, just kindly, where is mine? Yes.
Where is yours?
Just Milord's, just one point which he made towards the end, I just forgot.
This is information.
No, I am coming to that.
You can make the submission in your appeal.
Yes, yes, in my appeal.
Not in the,
Yes,
this cannot go on endlessly.
yes.
Yes.
No, just one point, Milord, the dissenting judge at one paragraph, he said, just 1 minute. He said parties have acted on it and have constructed the multiplex, which is wrong. Because the multiplex, just 1 minute, because, yes,
Yes, let's take up the second.
yes. Just kindly have Milord the award.
Yes.
Please have paragraph 135 of the award
Yes.
and a para 135 minutes. Milord, I would like to begin with by just pointing out that order of status quo which was passed by the Honorable Tribunal, which led to Milord's stoppage of the construction. How, Milord, I have suffered the most in this. Yeah.
Already given.
Oh, that Milord I have already given. The Lordship may just kindly have a look at. There is an order passed by the Honorable Tribunal on 27 days, January 2021. If your Lordship takes the last page, the parties were asked to maintain status quo. And this was, my lords, all in the middle of when the construction was going on. Last, my lords, on that last page, my lords, if your Lordships may have this page, my lords. The operative portion, my lords, I want to read. This page, my lords, the last page. At the bottom, at the application under section 17, the order, my lords, by the claimant is partly accepted. Both the parties are to maintain status quo as on the date till the completion of the proceedings. Now, my lords, please have, my lords, the award. And kindly have paragraph 135.
Yes.
This tribunal has rejected all the prayers of the claimant. The claimant has sufficiently spent on this litigation and has also made over the respondent's arbitral fees. The arbitral tribunal in its discretion is of the view that the claims, not mark this, it's not, I'm not able to read it.
130.
The arbitral tribunal in its discretion is of the view that the claimant is entitled for the cost of the proceedings to the extent that it has deposited the arbitral fees to the members of the arbitral tribunal on behalf of the respondent. Now please see, my lords, there is kindly see the operative portion of the award, which is, my lords, at page 83, my lords, of the award. of the award. In the result, the following award is passed.
Page 83 of the award.
Yes.
170 of the paper booklet.
Hmm.
Where it says, in the result, the following award is passed. The prayers of the claimant for specific performance and damages are rejected. The claimant is entitled for the cost of the proceedings to the extent that it has deposited the arbitral fees quantified at 42 lakhs made over to all the members of the arbitral tribunal on behalf of the respondent. Now, please see, Milos, in this, why I submit, Milos, that the award and cost on me is wrong. Kindly have, Milos, because at paragraph 135, that honorable tribunal does not give any reason except for saying that they have deposited the money and therefore you should pay them. Please have, Milos, paragraph, this is section, the F. Kindly have, Milos, section 31 and 31A. 31A was introduced, Milos, by an amendment after, Milos, the 246 Law Commission of India's report. And it, Milos, in paragraph, if your lordships may kindly have, Milos, section 31, form and contents of the arbitral award. It says at 31, Milos 3, the arbitral award shall state the reasons upon which it is based unless the parties have agreed that no reasons are to be given or the award is an arbitral award on the agreed terms under section 30. So party section 3, 31(3) requires, Milos, the tribunal to record reasons. Then, Milos, please see 31D. It says the cost of an arbitration shall be fixed by the arbitral tribunal in accordance with section 31A. Please have section 31A, regime for cost, in relation to any arbitration proceedings or a proceeding under the provisions of this act pertaining to the arbitration, the court or the arbitral tribunal, notwithstanding anything contained in the Code of Civil Procedure, shall have the discretion to determine whether the costs are payable by one party to another, the amount of such costs, and when such costs are to be paid. For this subsection, the cost means reasonable costs relating to the fees and expenses of the arbitrators, courts and witnesses, legal fees and expenses, any administration of fees of institution supervising, any other expenses incurred in connection with the tribunal, so and so, so and so. If the court or the arbitral tribunal decides to make an order as to the payment of the cost, the general rule is that the unsuccessful party shall be ordered to pay the cost of the successful party. Please note this. The court or arbitral tribunal may make a sufficient different order for reasons to be recorded in writing. So if the general rule is that unsuccessful party must bear the cost of the successful party. We can have a departure, but then the tribunal must then record reasons. This is the mandate of the act. Please see then, what are in determining the cost, that the court or arbitral tribunal shall have regard to all the circumstances, including the conduct of all the parties. I can understand if the tribunal found that you have delayed the proceedings. You took several adjournments, and therefore you should bear some of the liability for the cost. If the court says whether a succeeded party has succeeded partly in this case, whether the party had made a frivolous counterclaim leading to the delay in the disposal of the arbitral proceedings. I have made no counterclaim. Whether any reasonable offer to settle the dispute is made by a party and refused by the other party. Now please see Milos, section Milos 4. The court or the arbitral tribunal may make any order under this section, including the order that the party shall pay proportion so and so. All of these 4 would follow Milos 2 and 3. Now please see 5. An agreement which has the effect that like in this agreement, Milos, the arbitration clause says parties will share the cost of the arbitration. but then by legislature, my lords, has put in such section 31A5, where it says very clearly, then agreement which has the effect that a party is to pay the whole or part of the cost of arbitration in any event shall be only valid if such an agreement is made after the dispute in question has arisen. So a previous arbitration agreement, even if it records that the cost will be shared by the parties, such agreement will not be given effect to by the tribunal. If I'm 31A5. Such a consent can be given only after the disputes have arisen and when the parties make a reference to the arbitral tribunal. Similar clause, my lords, your lordships will also find where my lords, if your lordship sees section 12(5), where the court with regard to my lords, those my lords earlier, my lords, if your lordship, that anybody can be appointed as an arbitrator. Now then, my lords, what has happened, this the law came to be amended and said that 7th schedule was introduced and 5th schedule, where it says that if a person suffers from any one of the disqualifications which are set out in the 7th schedule and 5th schedule, such a person cannot be appointed. Please have, my lords, section 12(5), just to give a context, my lords.
Yes.
Section 12(5), notwithstanding any prior agreement to the contrary, any person whose relationship or with the parties or counsel or subject matter of the dispute falls under any of the categories referred to in subsection 7 shall be ineligible to be appointed as an arbitrator. Provided that the parties may, subsequent to the disputes having arisen between them, waive the applicability of the said section. Just to give the context, that through this amendment, the legislature made two things. That even if you had a agreement earlier with regard to any arbitrator being appointed, you cannot do so unless such a condition the parties again give their consent to such an appointment. And with regard to cost also, the legislature said, sorry, even if there is an agreement where parties have agreed in the arbitration agreement, that clause will, the cost of the arbitration will be shared by the parties. Section 31A5.
Yes.
Such a cost agreement will not be given effect to unless the parties have consented to such a condition, such a clause after the disputes have arisen. The reason behind this, of this amendment is this. Unlike when a dispute goes before the court, where the parties only pay the court fee, the cost before the tribunal is humongous. So if you drag a party to the arbitration, you must be sure of, you must be ready to pay the cost if you do not succeed in the arbitration.
Yes.
And that is what, the legislature has done it pursuant to, the 240, I just wish to place on record, the 246th, the Law Commission of India, the report, this thing. Why, how this, the amendment came to be made? Yeah. Arbitration, paragraph 70 of this, if I may just read. Arbitration, much like traditional adversarial dispute resolution, can be an expensive proposition. In this case, 84 lakhs was paid to the tribunal. The reason why we are seriously contesting it because, because of the status quo order, my cost of the construction escalated. And not only that, my project also suffered because there was a delay in the comment. Just 1 minute.
No pleading.
No, there is no plea. It cannot be because ultimately there is a cost. No, I have challenged that order and this thing. Now please see, the paragraph 70. Arbitration, much like traditional, I am not seeking recovery of that money. I am just placing on record the facts that because of the status quo order.
Without pleading.
No, just 1 minute. It is related to cost, which is why I am hurt. Because the tribunal, contrary to the statute, allowed the cost without even calling the parties to parties' arguments on it.
Yes.
It is just one email. It says arbitration, much like traditional adversarial dispute resolution, can be an expensive proposition. The savings of a party in avoiding payment of court fee is usually offset by the other costs of the arbitration, which include arbitrators' fees and expenses, institutional fees and expenses in relation to lawyers, witnesses, venues, hearings, etc. The potential for raking up significant costs justify a need for predictability and clarity in the rules related to apportionment and recovery of such costs. The Commission believes that as a rule, it is just to allocate the cost in a manner which reflects the parties' relative success and failure in the arbitration, unless the special circumstances warrant an exception or the parties otherwise agree only after the dispute has arisen before that. The loser pays rule logically follows. As a matter of law, from the very basis of deciding the underlying dispute in a particular manner, and as a matter of economic policy, provides the economically efficient deterrence against frivolous conduct and furthers compliance with contractual obligations. The Commission has therefore sought comprehensive reforms to the prevailing cost regime applicable both to arbitrations as well as the related litigation in court by proposing Section 6A to the Act, which expressly empowers the arbitral tribunals and the courts to award costs based on the rational and realistic criteria. This provision furthers the spirit of the decisions of the Supreme Court in Salem Advocate Bar Association versus, and it is hoped and expected that the judges and arbitrators would take advantage of this robust provision and explain the rules of the game to the parties early in the litigation so as to avoid a frivolous and meritless litigation and arbitration. Now, my lords, when I have filed Section 34 before, my lords, challenging this part of the award, my lords, the Honorable Court in Section 34 petition, the lordships may kindly see with me, lords, how the court has dealt with it. First, the court said, give me that award, Section 34, the judgment. In Section 30, while deciding this, it's a very short order. Just may allow me to read this order. Reasons, lords, which is at internal page 8, lords, of the arrest. It is only a contention of the learned counsel for the petitioner that the cost apportioned amongst the both parties is contrary to provision of Section 31A of the Act, as rightly contended by the learned counsel for the first respondent claimant. Modification of the award is not permissible when considering the petition under Section 34 of the work. Supreme Court in National Highway Authority, Mrs. M.S. Hakim, held that power to modify, vary, or remit the award does not exist under Section 34 of the Act. Further, it also does not dispute that the petitioner and respondent assailed the award in question so and so. Further, the petitioner respondent himself have produced Proceedings 6/12/2020 of the arbitral tribunal as per document 9. At paragraph 8 of the said proceedings, arbitrators' fee, miscellaneous fee charges was directed to be deposited by the claimant in view of the proviso to 38(2) of the Act. The deposit referred under this provision shall be payable in equal shares by the parties. Further, as per the proviso to 38(2), it is mentioned that if one party fails to pay the share of the deposit, the other party may pay that share. The arbitral tribunal has now directed the share of the petitioner respondent towards the fees deposited by respondent claimant to pay by way of the part of the impugned award challenge herein, as per the principles laid down by the Honorable Supreme Court. In the criterion, in the citation referred, supra modification of the award is impermissible. Accordingly, I answer point number 1 in the negative. So there are two reasons given by the Section 30. One, I cannot go into this question at all because setting aside the award on cost would mean modifying the award itself. And therefore, that itself not permissible under the judgment of the Honorable Supreme Court in Hakim. Second, which in my respectful submission, it has completely misconstrued an order which was passed with regard to initial deposits to be made by the parties under Section 38 as a reason for the apportionment of the cost. Your Lordships, I've read out Section 1, the paragraph 135. That is not a reason at all given by the tribunal. Even otherwise, the court could not, and I'm going to show, my lords, what 38 means, and the order which is referred to in this reasoning, my lords. 38.5 is a completely different altogether. That is nothing to do with the cost. That is when the tribunal starts at the very inception, the tribunal calls upon the parties to make deposits. And 38 says, because in this case, what had happened, initially, because the tribunal called upon both parties to pay, to deposit. Then I filed an application and an affidavit saying that, sorry, because Lordship knows that we are hit by the COVID at that point in time. The work had stopped and all of that had happened, my lords. We had loan liabilities towards the bank because we had incurred huge loan. We had taken huge loans from, my lords. They are, my lords, much well off. They're an international global company. We had taken huge loans from the bank. And because we are not able to, and then this whole COVID thing came, and therefore then we told the tribunal that please do not ask us to pay for this, share the cost. Please ask him to pay for the cost. If he succeeds ultimately in the arbitration, we refer to these provisions, 31A, he will be entitled to recover the entire cost from me in execution. Then the tribunal modified that order by referring to section 38(2) and said that, okay, because the claimant is not paying his expresses difficulty, respondent is not paying his expresses difficulty, therefore claimant must deposit the entire amount. That order, which was passed under section 38, was misconstrued to be an order, my lords, under section 31A. Now please have, my lords, on that modification, whether setting aside of the award only on the cost would amount to modification of the award itself, or whether it is permissible. On which, my lords, I have referred to, my lords, 2 and 3 judgments. Yes. In my written submission, this issue has arisen, my lords, in number of cases in Bombay and Delhi. And in Delhi recently, my lords, the court had actually called upon all the lawyers, my lords, to address the court on this issue particularly. And my lords, there is a judgment of the court which has come in 2023, my lords. I'm just going to rely on that. Just kindly have, my lords, those the arguments in the other. Just kindly have, my lords.
Written submission. They're
Yes.
seeing this compilation.
Huh?
They're seeing this compilation.
Hmm.
You tell to see this.
Yes. My lords, in my written submission, my lords, I have referred to 4 judgments in my written submissions. And please see, my lords, the first judgment in this, my lords. Just kindly have JG Engineers, my lords, in that compilation. I'll just quickly refer to, my lords. JG Engineers Private Limited versus Union of India. The page number 1 to 12 of 20 of the compilation. Just kindly have, my lords, at page 18, paragraph 25. This is, my lords, a Supreme Court judgment which has been referred to by the High Court.
Yes.
Just one. Please have, my lords. The issue arises. This one. This one. Just coming to that, because there is a reference to the judgment. Alcon Builders 469. The Bombay High Court, right? No. 486. This means there is a reference to this. Just allow me. Please have Miller's paragraph 5, page 23 of the compilation. The issues arises in context of section 34 of the Act, which comprises the power of the court to set aside an arbitral award. The issue of severability stood raised principally on account of proviso appended to section 34(2)(a)(4), which prescribes that if decisions on matters submitted to arbitration can be separated from those which were not, the unsustainable part of the arbitral award and which contains decision on matters not submitted to arbitration may alone be set aside. Kindly see this. The question which arose was whether the concept of partial setting aside or severance would stand restricted to a challenge to an arbitral award on grounds enumerated in clause 4 of the section 34(2)(a), or would it be so applicable to the other clauses falling in that part. The second aspect, which is conversed for consideration of the court, related to the scope and intent of section 34(4), which contemplates the court adjourning the proceedings on the request made by so-and-so to resume proceedings. Now, my lords, kindly have, my lords, the judgment, my lords, of my lords, the Bombay High Court, into the last judgment, my lords, in the compilation, 2022 SCC online, Bombay 1688. (486).
Yes.
In this case also, my lords, the question which was, my lords, gone into was whether, my lords, partial setting aside of the arbitral award is possible. And, my lords, the judgment sought to be referred to, my lords, in this case was also, my lords, the McDermott's judgment, the judgment of the Honorable Supreme Court in the case of McDermott. And, my lords, if your lordships may kindly see, kindly come to paragraph 20 of this judgment. The said question has been engaging the attention of this court, and it was found that there were divergent views of the division benches of this court, leading to the question being referred to a full bench of this court in the case of RS Jiwani versus Irkan International Limited. The full bench of this court framed the severability can be applied to an award while dealing with an Conciliation Act. What is the scope of proviso to section 34(2)(4) and whether its application is restricted to clause 4 alone, or it applies to the whole of section 34(2) of the Act. After referring to the various precedents and discussing the law in detail, the full bench of this court in the aforesaid case held as follows. And, my lords, we may now revert back to the facts of the present case, which is itself a glaring example of what the devastating results can be produced by accepting a contention which has been raised on behalf of the respondent in the present appeal. Undisputedly, claims were adjudicated upon the merits. Parties laid evidence. Arbitral tribunal allowed some claims of the claimants and rejected all the remaining claims of the claimants and the counterclaim filed by the party. The claimant was satisfied with the award. An enforceable right by way of decree accrued to the claimant in terms of section 32, 35, and 36 of that. The company approached this court by filing a petition under section 34, which partially allowed in the sense that out of the 15 claims allowed by the arbitrator in favor of the claimant, held that other claims were not payable to the claimants, but still did not make any observation that the award insofar as it rejects the remaining claims and the claims counterclaim and unsustainable. However, to conclude, the learned single judge, despite having upheld the claims in favor of the claimant, they set aside the entire award in view of the division bench judgment in the case of so-and-so murder. Could there be a greater perversity of justice to a party which had succeeded before the arbitral tribunal as the court of law, but still does not get a relief? Is that what is contemplated and was the purpose of introduction of the Act of 1996, an act which was to provide, I'm skipping this part, Paragraph 37, just 36, the last sentence, to say that it is mandatory for the court without exception to set aside an award as a whole and to restart the arbitral proceedings all over again would be unjust, unfair, inequitable, and would not in any way meet the ends of justice. The interpretation put forward by respondents is bound to cause greater hardship, inconvenience, and even injustice to some extent to the parties. Then, my lords, if your lordships may kindly see same paragraph 37, last 4 or 5 sentence, there is nothing in the provisions of the Act, and for that matter, absolutely nothing in the model law, which can debar the court from applying the principles of severability, provided it is otherwise called for in the facts and circumstances of the case and in accordance with the law. The court will not get into the merits of the dispute. Thus, the interpretation which should be accepted by the court should be one which will tilt in favor of the model law so-and-so. For the reasons aforesaid, we are of the considered view that the dictum of the law stated by the division bench in the case of Mulchandani is not the correct exposition. Now, my lords, if your lordships may kindly see that, my lords, paragraph 22, thus it becomes clear that in a given case, the court, while exercising the power under section 34 of the Act of 1996, can set aside an award partly, depending upon the facts and circumstances of the case. In this context, the reference can also be made to the judgment of the Honorable Supreme Court in the case of JG Engineers Private Limited versus Union of India, which I just referred to. In the said case also, the doctrine of severability was invoked, and it was held that when an award deals with several claims that can be said to be separate and distinct, the court can segregate the award on the items which do not suffer from any infirmity and uphold the award to that extent. Thus, it becomes clear that the contention raised on behalf of the appellants in the present case that the PDG ought to have been set aside, set aside the arbitral award in its entirety is not justified. So, my lords, my submission is, when, my lords, the award and cost, that it is completely separate from, my lords, the award on the merits. There is no connection to this. There is no reasons recorded for passing the award on cost, and therefore, that being, my lords, a separable issue from the main issue, that can be, my lords, set aside by the court in section 34. It cannot be, my lords, said that if I set aside the award, if the award and cost, I have to set aside the entire award. That, my lords, is wrong. That, my lords, an award can be partially set aside, and my appeal could have been, my lords, entertained by the court. The second, my lords, is, my lords, if your lordships may kindly see patent illegality, because ultimately in 34, I have to succeed on this ground, that the award on cost suffers from a patent illegality. Now, my lords, the judgment in, my lords, the associate builders, my lords, on this Bombay High Court, there are 2 other judgments. I am not reading it. Just, my lords, your lordships will take note of, my lords. The Delhi High Court judgment in the serial number 7, Union of India versus Alcon Builders Limited. Here, my lords, there was a specific award on cost which was set aside by the High. Serial number 7.
Yes.
And court Millards applied the same Millards severability principle. And Millards, your lordships will also take note of the recent Delhi High Court judgment, which I Millards mentioned just now. Is Millards at serial number 2, National Highways Expressway versus Trichy Thanjavur Expressway Limited. Your lordships may just note the paragraph number, paragraph 87 at page 158. That's Millards the conclusion, Millards, where the court has Millards held.
Yes.
In this Millards, the issue was precisely this, whether if some of the claims which are awarded by the tribunal are completely distinct and separable from the remaining. In section 34, can those findings on those claims be Millards set aside or not? And the court said yes, it can do so, applying Millards the severability principles. Those principles are Millards laid down at paragraph 158 to 163 Millards of the judgment.
Yes.
Now Millards may kindly have Millards the judgment of the Supreme Court Millards, the Associate Builders versus Delhi Development Authority, which is at Millards serial number 6 of the compilation. Your lordships may kindly have Millards page 425, and Millards may kindly go straight away to paragraph 42.2. Now I must tell your lordships, Millards, Associate Builders is a case which was before the amendment came, and which is why Millards then in Sanyong, the court revisited Millards Associate Builders to find out how, to what extent the judgment of Associate Builders is relevant after Millards the amendment. Your lordships may kindly have paragraph 42.2 of this judgment. Page 425, it starts, Millards. That's I'll take Millards about 10 minutes.
Yes, we see
Yeah.
the
Yes, paragraph 42.2 Millards. Lordships may just kindly see. A contravention of the Arbitration Act itself would be regarded as a patent illegality. For example, if an arbitrator gives no reason for an award in contravention of the section 31(3) of the Act.
Yes.
42.2 Millards.
Yes.
Such award will be liable to be set aside. This Millards has been held to be Millards in Sanyong's case. Kindly have Millards page 290 to 359 at paragraph Millards 39.
Yes. Yes.
Yes, in there Millards. Paragraph Millards 39. Paragraph 39, Millards, page 329. To elucidate para 42.1 of Associate Builders, namely a mere contravention of substantive law of India by itself is no longer a ground available to settle. Para 42.2 of Associate Builders, however, would remain for if an arbitrator gives no reason for an award and contravenes section 31(3) of the 1996 Act, that would certainly amount to a patent illegality on the face of the award. In my case, Millards, paragraph 135 does not give any reason at all. That is, Millards, not only against 31(3), but is also against Millards section 31A, 2, Millards, that sub Millards, the subclause, which says if you depart from the principle that Millards, the loser has to bear the expenses, then you have to record reasons. And that, Millards, in my humble submission, is a mandatory. Now, Millards, what the section 34 court also does is, it makes reference to an earlier order. That Millards, I just like to quickly show as to why it is not relevant. But just kindly before that, kindly have, my lords, the section 38 of the Act.
Yes.
38 of the Act, my lords. It is about the cost deposits.
As an advance for the cost referred to. in
Yes,
CH-3.
the tribunal may fix the amount of deposit or supplementary deposit as the case may be as an advance for the cost referred to in subsection 8 of section 31, which it expects will be incurred. 31(8), your lordships have said, seen, my lords, which says that you will determine the cost as per 31(a).
Yes.
It says as an advance for the cost referred to, so which it expects will be incurred in respect of the claim submitted to it, provided where that apart from the claim, a counterclaim has been submitted to the arbitral tribunal. It may fix separate amount of deposit for the claimant. Now please see, the deposit referred to in subsection 1 shall be payable in equal shares by the parties. It is deposit. The court has to ultimately, it has to decide the cost at the end of the arbitration proceedings under 31(a).
Yes.
It says, provided where one party fails to pay his share of the deposit, the other party may pay that share. The
Yes.
order which was passed at the very inception of the arbitration agreement, arbitration proceedings, and kindly have that order, Millers. I'll just quickly show that order. Yes.
That may not be required to
Ah.
understand the content.
So, Millers, that order was passed, Millers, with regard to deposit.
Yes.
And parties were called upon to deposit that, pay that amount. I filed an application immediately saying that I am not in a position, I have taken huge loans. I have filed my bank statements, everything, Millers, along with an application
Yes.
to show, Millers, my liabilities. And I said, Millers, please do not ask me to bear the burden of the arbitration tribunal.
Yes.
Tribunal agreed with me saying, no, let him pay, let the claimant deposit. They paid.
Yes.
And then, Millers, that order has been misconstrued by the Millers, this Honorable District Judge, Commercial Court, Millers, as being an order under 31(a). 31(a) can be passed only at the end of Millers, at the end of the Millers arbitration.
Yes.
Millers.
Yes.
First submission respectfully is that it is not. The lordship may kindly see the contract. I will show my lords. Contract. The conduct of the parties before the arbitral tribunal. In both of these, the parties agree they will share costs, not the cost. What happened before the arbitral tribunal is merely a reflection of what the parties originally agreed in the arbitration. Lordship may kindly have the very same convenience compilation your lordship may see. Exhibit C1 is at page 20.
Paragraph, page.
Page 20 is where it starts. The arbitration clause, the lordship will please have on page 13.
Yes.
In case of a dispute, the parties at the first instance shall amicably, if not settled, then the panel of 3 arbitrators shall be appointed in accordance with the Act. The cost of such arbitration proceedings shall be borne. This was the original agreement of the parties.
Yes.
Then your lordship may kindly see not. In the appeal memo that my learned friend has filed, if your lordship will please come to page 233, annexure G.
Yes.
Page 233, my lords, annexure G.
CH-3.
Lords, this is in appeal number 266. I'm sorry, 166.
166. Yes.
What is the? What do you want to that part?
27/8/2020.
27/8/8. Document number 4.
Document number
4. That's at page 50 minutes.
Well, the numbering is at document number 4. This is the modified minutes of the preliminary sitting. 27/8/2020. Yes.
So in this, your lordship can please come to clause 6.
Yes.
With the consent of the parties,
Yes.
with the consent of the parties and the learned counsel appearing on either side. Those words may kindly be noted. Consent of parties and counsel. The fee of the arbitrators and the expenses in relation to the conduct of the proceedings are fixed as hereunto. Fee of the arbitrator shall be paid a sum of rupees 1.5 per sitting and shall be shared equally between the parties. And they shall be paid an advance of rupees 6 lakh.
Yes.
These words shall be equally shared between the parties. Is a common, your lordship will also see B for a The reading fee is provisionally fixed at rupees 3 lakh and shall be equally shared between the parties.
Yes.
If I may therefore pause for a moment and submit. The deposit that is being referred to in 38 is advance of 6 lakhs in 6A. The cost is 1.5 lakh per sitting. In this case, the parties agreed on both counts. They said, this is the cost, I will bear it equally. This is the advance, I will pay it equally. There was an agreement on both. Therefore, my lords, same agreement that is found in the arbitration clause is reflected here. This is after the dispute. It goes to arbitral tribunal, recorded by the tribunal, where they say will be shared equally. Both components are covered.
Yes.
It is thereafter that, like many parties who enter into arbitration, suddenly one party who does not have a counterclaim to prefer will find itself in financial trouble. Because my lords, I have filed a claim petition, I have no choice but to go on making payments. I am compelled. There also your lordship may kindly see, my lords, the page, that is the very next document. Even in that document, lords, 19th November 2020, there is a letter by the council.
Yes. Yes.
Lords, even if I may just read the first paragraph of the letter, the point I wish to make is, even here they don't say, I am not agreed. That is not the point. They say, I am in financial difficulty, therefore today I am not able to honor.
Yes.
That is all.
Just plus the last 4 sentences in the first paragraph. This honorable tribunal is
I read
humbly,
it, sir.
yes.
Yes.
I read numbers, the lines that my learned friend says. This honorable tribunal is humbly requested to direct the claimant to deposit the entire fee and cost of this arbitration. Needless to state that the claimant will be entitled to recover the respondent share of fee if it succeeds in the matter.
Made it very clear. That
No, I
has
will
to
not
be decided in the end.
Yes.
all I'm saying is the agreement has not been gone back on. This is a legal submission that he makes. But nowhere does he say, I never agreed to pay equally the fees. He simply says, today I don't have money, please today excuse me.
Yes. Yes.
But after this, the Honorable Tribunal of course says, all right, if they are not, then your lordship may kindly come to my lords. They file an affidavit before the tribunal. The affidavit begins, the cover page is 4/12/2020 of the affidavit. The relevant paragraph of the affidavit is para 5 and 6.
Yes.
The respondent states that abiding by the procedure of fee sharing laid down by this Honorable Tribunal in Procedural Order number 1 will be extremely difficult. Again, they don't dispute the order or its contents or its implications.
Yes.
Needless to state that this Honorable Tribunal may under section 38 so and so.
Yes.
In short, my respectful submission is they will open agree.
Please read the next order.
Once they agree with openness, they cannot call it.
Yes.
That is my submission so far as the conduct of the parties is concerned. There is also an order, perhaps in my book it is at 262 of the tribunal. In para 7 of the order is relevant. The tribunal reiterates that the parties have agreed to share the fees and expenses.
Can you please tell us
both the parties.
number in the copy that has been given to us? Instructing counsel.
Yes.
Let's page 80.
Page 80.
81.
Yes.
81.
Yes.
You see, para 7 your lordship.
Yes.
We notice that under 38(2), both the parties are required to share the fees and requisite expenses. The proviso indicates that only one party gets pay share of deposit, the other party may pay the share. Then para 8, last 2 lines, but we have no option but to direct the claimant to deposit the aforesaid charges in view of the proviso 38(2).
Yes.
This is the order.
Please read paragraph 8 fully.
Now, my lords, my respectful submission on the provisions of the Arbitration Act are
Yes.
section 31, subsection 31A, subsection 5. In my respectful submission, my lords, therefore squarely applies to the facts of this case. This is an agreement where the party has agreed to pay part or whole of the costs, and this agreement is reflected in the first procedural order.
Yes.
31A(5). An agreement which has the effect that a party is to pay the whole or part of the cost of the arbitration of any event shall be only valid if such agreement is made after the disputing question has arisen. This agreement is reflected in the first procedural order. Says parties and counsel both agree.
Yes.
Second, my lords, 31A says that it is the imposition of costs will be in the discretion of the tribunal. 31A shall have the discretion to determine.
Yes.
In this case, section 16 application is filed by the claimant. I'm sorry, by the respondent. That is turned down. On merits, the tribunal turns down my claim. Both the parties therefore have made one claim which the tribunal turns down.
Not clear.
Yes.
Therefore, once the tribunal says share the fees equally. How is this an improper exercise of discretion? It will shock the conscience of this honorable court.
Yes.
Then, my lords, subsection 2 only says the general rule.
Yes.
In this case, I am not the party who is entirely unsuccessful on 2 counts. One is on the application under section 16, which is an award in itself, because it is challengeable under 34. Section 16 subsection 5 says an order under 16 can be challenged under 34. I am not unsuccessful. So also, my lords, there is a minority award in my favor. So I am not entirely unsuccessful. In these circumstances, the tribunal exercises its jurisdiction The tribunal has recorded its reasons in writing. Tribunal says in para 135.
Yes.
The sufficiency of those reasons may not be tested in 34 and 37. Once it's done for some judgments, once it is for 15 minutes on another day, I will just distinguish those judgments. Because there are 3 judgments of the Supreme Court, which in my respectful submission, this is all on facts. 10 to 15.
Yes. We will be opening us to a further reply and a reply to a reply.
The only difficulty is that
In McDermott and in Ravisa, Supreme Court says an award cannot be modified. So I just need to show those 2 judgments. But on facts, this is all this.
Yes, when do we complete the other? Every day after today appears to be only booked even at 2:30.
Any date, any time your lordship not sees.
5th of September. 5th,
I'll join Millard's.
on condition that it will be complete on that day.
Yes, I will not take more.
When so much of argument is being addressed and we leave it for a
Long date.
long date,
Naturally.
it's difficulties.
Yes, yes.
After having argued the matter. we
Millards,
already started
I have already filed Millard's the written submission. Just on my additional, sir rejoined the arguments that I had made. I'll just file a 1-page Millard's. Just a 1 page.
Yes. Written submissions are always welcome,
Yes.
so long as they are shown.
Yes, yes, I understand.
Yes.
To my written submission, therefore, not, I put an index so that whatever your lordship is being.
Yes.
So
Grateful, Millards. Grateful for a very patient hearing.
All of the matters which are not taken up today, we have to assign dates. Please get the dates from the.
One submission, Milord, serial number 62, I got the appellant, Milord, on-site counsel and also present. Will be taken up after 2 weeks, Milord. Need date coming into this. 62. Any date after 2 weeks, Milord. Serial number 60.
30th.
30th.
All of the matters, please get the dates.